All right. So we will be watching together. We're going to be starting here soon. All right.
Any business we need to take care of before we bring the jury in?
No, Your Honor.
Evans, you'll be up first.
Yes, Your Honor.
You can bring in the jury.
Can you guys hear? This is the young Dolph trial, okay? This is going to be closing arguments. And we're going to see what they're going to say about this trial, you guys. Pardon me clicking because I'm working, okay?
Ladies and gentlemen, before the jury comes in, I will start to read this jury charge very soon. There will be no movement during the charge. The door will be locked. Nobody will enter and nobody will exit. It's going to take me about 15, 20 minutes to read this charge. So if you don't feel like you're going to be able to sit still during this time frame, please exit now. Thank you.
Jury time, enter into the courtroom, Your Honor.
We'll get ready to get started, you guys. Thanks for being here, everyone.
Good morning.
Good morning.
I'm trusting again that right now tonight. Mr. Evans, can you call your first witness?
Your Honor, the defense rests.
Ladies and gentlemen, you have heard the proof in this matter. What you have had in your seats, is a jury charge. This is my portion of this trial. It's the law. Now, the law states that I have to read it to you. Please don't think I am insulting your intelligence by reading to you. I know you can read for yourself, but the law states that I have to read it, and you all have to read it at the same time. Okay. That is your copy. Feel free to write on it. I have the official copy here that will go back with you to the jury room. You cannot write on this copy, but feel free to make any notes that you'd like to make, and any changes that I have to make that I see that need to be made will be made on the official copy. State of Tennessee versus Justin Johnson. Members of the jury. The evidence in this case has been completed, and it is now my duty to instruct you as to the law. After I instruct you as to the law, the state and the defense may present their closing arguments. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out any one or more of them to the exclusion of another or others, but should consider each one in light of and in harmony with the others. Duties of the court and the jury. The law makes it the duty of the court to charge the jury the law relative to the case on trial, and the duty of the jury to carefully consider all of the evidence delivered to them in the trial and under the law given them by the court, render their verdicts with absolute impartiality. No sympathy or prejudice by the jury. You can have no prejudice or sympathy or allow anything but the law and the evidence to have any influence upon your verdicts. You must render your verdicts with absolute fairness and impartiality as you think justice and truth dictate.
Hey, can you hear
Right.
us?
As
You know who doesn't hear us? Brian Kemp in Georgia.
We're
The
back.
crimes. It is not evidence against the defendant and does not create any inference of guilt. Statements and rulings of the court. At times during the trial, I have ruled upon the admissibility of evidence. You must not concern yourself with these rulings. Neither by such rulings, these instructions, nor any other remarks which I have made, do I mean to indicate any opinion as to the facts or as to what your verdicts should be. Statements and arguments of counsel. Statements, arguments, and remarks of attorneys are intended to help you in understanding the evidence and applying the law, but they are not evidence. If any statements were made by the attorneys in this trial at any time that you believe are not supported by the evidence, you should disregard them. Along these lines, the opening and closing arguments of the attorneys are likewise not evidence. You must base your decision in this case on the evidence that was actually presented in this court, not on the statements of attorneys. Furthermore, the questions the lawyers ask the witnesses are not evidence. You should not think that something is true just because one of the lawyers asks questions that assume or suggest that it is true. Jury, judges of facts and law. You are the exclusive judges of the facts in this case. Also, you are the exclusive judges of the law under the direction of this court. You should apply the law to the facts in deciding this case. You should consider all of the evidence in light of your own observations and experiences in life. Presumption of innocence. The law presumes that the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial and is not overcome unless all the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. Burden of proof. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. The state must have proven beyond a reasonable doubt all of the elements of the crime charged and that it was committed before the finding and returning of the indictment in this case. Reasonable doubt. Reasonable doubt is that doubt engendered by an investigation of all the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element necessary to constitute the offense. Crimes charged and plea. The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within the offense are the lesser included offenses: facilitation to wit, conspiracy to commit first-degree murder. The second count of the indictment charges the offense of first-degree murder. Embraced and included within the offense are the lesser included offenses of second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. The third count of the indictment charges the offense convicted felon in possession of a firearm. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first-degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of conspiracy to commit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained, and that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder, and that each party acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of this conspiracy. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed, or the agreement that they be completed is abandoned by the person and by those with whom the person conspires. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures, other than silence, for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when the person advises those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. However, mere presence is not sufficient to support a conviction. Facilitation to wit, conspiracy to commit first-degree murder. Any person who commits the offense of facilitation to wit, conspiracy to commit first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the conspiracy, and that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on page 4. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable in count 2 in this indictment. First-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted knowingly. Knowingly means a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Facilitation to wit first-degree murder. Any person who commits the offense of facilitation to wit first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of first-degree murder, but did not.
Kamala supports taxpayer-funded sex changes for prisoners.
Surgery.
For
prisoners, every transgender inmate in the prison system would have access.
Kamala's for they, them. President Trump is for you.
Wix gives you the freedom to tell your story.
And that the defendant furnished substantial assistance to that person in the commission of the first-degree murder, and that the defendant furnished such assistance knowingly. First-degree murder has been defined on page 8. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, second-degree murder. Any person who commits the offense of facilitation to wit, second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of second-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit from the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the second-degree murder, and that the defendant furnished such assistance knowingly. Second-degree murder has been defined on page 9. Knowingly means that the person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted intentionally or knowingly, and that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which renders the mind incapable of cool reflection. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, voluntary manslaughter. Any person who commits the offense of facilitation to wit, voluntary manslaughter is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the voluntary manslaughter, and that the defendant furnished each such assistance knowingly. Voluntary manslaughter has been defined on page 13. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of a person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any person who, facilitation to wit aggravated assault. Any person who commits the offense of facilitation to wit aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the aggravated assault, and that the defendant furnished such assistance knowingly. Aggravated assault has been defined on page 14. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Simple assault. Any person who commits a simple assault upon another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant caused bodily injury to another, and that the defendant acted either intentionally, knowingly, or recklessly. Facilitation to wit simple assault. Any person who commits the offense of facilitation to wit simple assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of simple assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the simple assault, and that the defendant furnished such assistance knowingly. Simple assault has been defined on page 18. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 3 in this indictment. Convicted felon in possession of a firearm. Any person having been convicted of one of certain specific felonies who possesses a firearm is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant had been convicted of a specified felony, and that the defendant, after such felony conviction, possessed a firearm, and that the defendant acted either intentionally, knowingly, or recklessly. Firearm means any weapon that will or is designed to or may readily be converted to expel a projectile by the action of an explosive. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to the results of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the results will occur. The risk must be of such a nature and degree.
When the everyday excess falls away and we instead prioritize what matters,
Ordinary person would exercise under all the circumstances as viewed from the accused person's standpoint. If you find from the proof that the defendant has been convicted of another crime or crimes than that for which he is presently on trial, you may not consider such evidence as proof of his disposition to commit the crime for which he is on trial. The defendant has pled not guilty to each and every offense charged and included in the indictment. Direct and circumstantial evidence. One type of evidence is called direct evidence and the other type is called circumstantial evidence. Direct evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which give you clues about what happened in an indirect way. It consists of all the evidence which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all the evidence presented in this case by the state and by the defendant and give it full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified? In other words, how well could the witness see or hear what he or she testified he or she saw or heard, whether the witness's statements were consistent and how believable the statements were, whether the witness had a motive to testify truthfully or to testify untruthfully, and any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Another factor for you to consider in evaluating a witness's testimony is whether the witness has made material statements at some point before he or she testified, which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof in the trial. Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable. However, immaterial or minor discrepancies or differences should not affect the believability of a witness unless it should plainly appear that the witness has willfully testified falsely. Criminal responsibility for conduct of another. The defendant is criminally responsible as a party to the offense of first-degree murder if the offense was committed by the defendant's own conduct, by the conduct of another for which the defendant is criminally responsible, or by both. Each party to the offense may be charged with the commission of the offense. The defendant is criminally responsible for an offense committed by the conduct of another if, acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempt to aid another person to commit the offense. Intent means that the person acts intentionally with respect to the nature of the conduct or to the results of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. To find a defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Absent material witness. When it is within the power of the state or the defendant to produce a witness who possesses peculiar knowledge concerning facts essential to that party's contention and who is available to one side at the exclusion of the other, and the party to whom the witness is available fails to call such witness, an inference arises that the testimony of such witness would have been unfavorable to the side that should have called or produced such witness. Whether there was such a witness and whether such an inference has arisen is for you to decide, and if so, you are to determine what weight it shall be given. This inference does not apply to the defendant because he has a lawful right not to testify, and his failure to testify cannot be considered for any purpose against him, nor can any inference be drawn from such facts. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such facts. Stipulations. A stipulation is an agreement between the parties. The parties have stipulated that certain matters of fact are true. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proved. The parties have entered into two stipulations. The parties have stipulated that Adolph Thornton Jr. was a living person who is now deceased, and an autopsy was performed to substantiate these facts. The parties have also stipulated to the fact that the defendant, Justin Johnson, is a convicted felon, previously convicted on May 2nd of 2017 in Division 8 of the Criminal Court of Shelby County. Flight. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community or leaving of the community or parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the facts of flight. If flight is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Multiple counts, finding of each required. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Notes. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. Deliberation, order of consideration. In reaching your verdict, you should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. That is the law, ladies and gentlemen. We will now proceed with closing arguments.
Good morning.
Good morning.
So it's almost over, and I'm sure you all are happy. My name is Iris Williams. I'm one of the prosecutors on this case. And earlier this week, you heard opening statements. You heard opening statements from prosecution and from the defense attorney. And you were told all the things that you could expect this week. And one of those important things that you could expect was that it is not 1981 and that things have changed. But what does that mean? It means that it's hard to keep a secret. It's hard to hide who you're talking to. It's harder to hide your actions. And it's even harder to hide who you know. But ladies and gentlemen, despite all of those things that have changed, one thing has not changed, and that is the state's burden. The state's burden of proof is beyond a reasonable doubt. So what does that mean? Where are we? So the defendant, Justin Johnson, is charged with 3 counts: conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. So I know that you've already gone through a little bit of this law during voir dire, and especially through the jury instructions. But a brief overview of conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder. 2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acted for the purpose of promoting or facilitating the first-degree murder. And 4, 1 or more of the parties committed an overt act to help the crime happen. So what did we hear this week? This week we heard testimony from co-defendant Cornelius Smith. He testified for us and he told us that he met Justin Johnson through Hernandez Golan, and that he knew
Trump's Project 2025 would take Black America backwards. It would strip away our voting rights protections and bans abortion. Kamala Harris will stand up to Trump and his dangerous plans to control our lives, because Trump is out for himself, while Kamala Harris is for the people.
Smith told us that on November 17th, 2021, he and the defendant knew that Big Jook had a $100,000 hit on Dolph's head. Cornelius said that he and Justin agreed to kill Dolph together, and both of them receiving $40,000 apiece. Not only did he tell us that, he told us that this plan had been in process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson was an active participant in those agreements. So there we have it, a conspiracy to commit first-degree murder. An agreement was made. Each of the parties had the intent to commit the first-degree murder. Each person acted for the purposes of promoting and facilitating. And, ladies and gentlemen, the overt act is the killing. Next, first-degree murder. In essence, a first-degree murder is a premeditated killing of another. What's required for first-degree murder is 1, that the defendant unlawfully killed the victim. The only way to lawfully kill someone is if you are in protection of yourself or others. 2nd, you have to prove that this defendant acted intentionally. Intentionally means that there was no mistake, there was no accident. 3rd, you have to prove that the killing was premeditated. And as we saw, or as we learned in voir dire last week, premeditation does not mean that you had to have this plan for months, weeks, or days in advance. It could just mean that you simply stepped out of your car, you held up your hand, you pointed a gun, and you shot and killed somebody. As long as you had a moment to think about what you were doing, that's premeditation. Next, so we heard from a couple of people this week. First, we heard from the victim's sister, Erica Thornton. She testified that the victim was a living person. He had a family, he had children. She's known him her entire life. She attended and planned his funeral service. And coupled with that, defense counsel and the prosecution agreed to a stipulation, which just means that they agreed to establish that this victim was a living person who is now deceased. Later on, we heard from Dr. Scantleberry. She was the medical examiner and performed the autopsy. She found that there was a total of 22 gunshot entry wounds, including gunshots to the back torso, front torso, head, neck, upper extremities, and vital organs.
Wow.
She also testified that on the property that was collected from the victim, there was no weapon. And we also heard from Raul Hopkins. He testified that he was head of Dolph security for years. He was able to identify Dolph's car in the beginning of the Makitas video, and he was also able to explain the difference between CMG and PRE, their history of conflict, rivalry, diss tracks, and even prior acts of violence that were towards Dolph. So with all of this testimony, we've established that there was a killing and that the victim was Adolph Thornton Jr. But was that killing unlawful? Was that killing premeditated? And was that killing intentional? Back to Cornelius Smith. In addition to testifying about the agreement that he and the defendant entered into, he also testified about the killing. He said that on the day of the murder, the defendant picked him up from his father's house. They both knew that the victim was doing a turkey drive with several of his PRE artists. They also knew that Big Jook had a hit out on all of the PRE artists. So it was their job that week to find them. And on November 17th, 2021, Cornelius Smith and Justin Johnson were on their way to a turkey drive in Westwood. As they were about to turn the corner, they saw a familiar car cross the intersection, which happened to be Dolph's car. Cornelius tells us that they followed the car, made a loop onto a back street, and then entered the Makitas parking lot. And this happened, I want to say, about 30 seconds after Dolph and his brother arrived at Makitas. Cornelius Smith was able to point out himself in that video and the defendant in that video. And he said that both of them were the shooting suspects in that video. The second suspect that got out of the car was wearing a black hoodie, gray pants, black shoes with white soles, and a Bass Pro hat. The same clothing that defendant Justin Johnson was seen in as he was exiting his apartments at the Crosstown Concourse. After the shooting, Cornelius Smith testified that they got into the white Mercedes that they committed the act in. They went to Bradley Street. The defendant parked the white Mercedes on the yard, and they both got into a white Ford Expedition. They both got into that Expedition, and on the way, a couple of calls were made, right? Cornelius tells us that a FaceTime call was made to Big Jook. In that FaceTime call between Big Jook and our defendant spelled out the word Dolph. And as they were on their way to the Gospel Gardens apartment, the defendant also contacted a few other people who we'll find out later on. So once the defendant and Cornelius Johnson arrived at Gospel Gardens, they received wound care. They change their clothes, and then they go their separate ways. After they go their separate ways, Cornelius Smith tells us that he went to retrieve his phone, and he went to go wipe down the car, the white Mercedes that was parked at Bradley. So with Cornelius Smith's testimony, we have established that the killing was unlawful. There was no evidence to show that this defendant was in fear, was protecting himself, or was protecting someone else. We also established that it was intentional. It's not an accident. You didn't mistakenly follow someone's car into Makita's parking lot and then shoot them. We also established that it was premeditated. They knew about this hit beforehand, and they committed this hit. So if that wasn't enough for you, we heard from some other people. We heard from Kirsten Gardner. He testified that he was present during the time that the defendant was able to get possession of the white Mercedes that the act was committed in. Kirsten Gardner was at the Valero gas station in the early hours of November 17th, 2021. Next, well, actually, let me go back to Kirsten Gardner. After he testified that, he told us that he didn't know anything about what was happening the next day, or that a few hours after the cars were switched. Similarly, Jamarcus Johnson didn't know anything either. He just knew that he needed a ride. And his brother, Justin Johnson, could provide that for him. So he got his car, the rental car, and he took his cell phone, he fielded his calls, posted on his social media, and checked his emails. After Jamarcus Johnson, we heard from Sergeant Dabney. He was able to tell us about the 4 different bullet casings that were present at the murder scene. .40 caliber, attributable to a handgun. .762, attributable to an assault rifle that Cornelius Smith had. .223, attributable to a semi-automatic that Marcus Thornton probably would have had. And a 9mm casings found inside the store, which could be attributable to the handgun that Marcus Thornton had inside the store. That first one, though, the .40 caliber attributable to a handgun, was in the hand of the suspect with the Bass Pro hat. So, Sergeant Dabney also recovered the surveillance footage from Nikita's and Gospel Gardens, showing this suspect in the same clothing that the defendant was in as he was leaving his apartment at 10:49 a.m. that morning. The timestamps on Gospel Garden and Nikita's coincide with the times defendant's phone accessed those towers. We heard from Special Agent Garner, who summarized that the defendant's phone accessed a tower that provided coverage to the Valero gas station at 3:17 a.m. Around the same time that Kirsten Gardner said that he saw the defendant take possession of that white Mercedes at the Valero gas station. The defendant's phone also accessed towers that provided coverage for the area of 2370 Airways Boulevard, which is our murder scene. And it accessed those towers during the times of the murder, 12:22 p.m. to 12:23 p.m. on November 17th. Officer Garner also explained that the defendant's phone accessed a tower in the area of the 2-lane road in Shelby Drive from 1 p.m. to 1:59 p.m., which is the direct correlation to the surveillance footage of Gospel Gardens and the footage that Officer or Sergeant Dabney identified the defendant being present for. So next, if all of that wasn't enough, we heard testimony from Sergeant Browning. Sergeant Browning said that this defendant's device placed an outgoing call to Anthony Mims at 12:25:40 p.m. on November 17, 2021. Not only did he place an outgoing call to Big Jook, he also received a text from Kiana Hooper, who is his cousin. She texted him an address of 4752 Haven Court. After he received that address, he then sent that address to an associate named Jermaine Sears. Jermaine Sears, or defendant's device.
Kayak. Why do people use kayak to compare hundreds of travel sites at once?
Arrived shortly after the defendant arrives in a white Ford Expedition. So the next thing, convicted felon in possession of a firearm. The 3 things that we have to prove beyond a reasonable doubt is that 1, this defendant was a convicted felon or convicted of a specified felony. And 2, after being convicted of a felony, this defendant possessed a firearm. And 3, this defendant acted intentionally, knowingly, or recklessly. So the facts that we have for this charge. Well, one, there was a stipulation or an agreement. The parties have stipulated that defendant Justin Johnson was convicted of a felony on May 2nd, 2017 in Criminal Court 8 in Shelby County, Tennessee. Next, we heard testimony from Cornelia Smith, who verified that the person in that Bass Pro hat was Justin Johnson, and that person held a gun. So based on all of that, we can see that we have met our burden of proof for convicted felon in possession of a firearm. Next, let's just talk about reasonable doubt for one last second. Reasonable doubt, it is not 100% certainty. It is not beyond a shadow of a doubt. It is not beyond all doubt. What's required is moral certainty. Certainty that allows you to sleep well at night. Will you be able to rest easy knowing the decision that you made? My instinct says yes. And once you've had time to deliberate, I think yours will too. So that brings us to the end. The state has met its burden of proof beyond a reasonable doubt. You have all the evidence, all of the testimony, all of the stipulations, all the videos, all the photographs. And now it's time for you to consider that evidence and apply your common sense. And after you do that, I expect that you will find this defendant guilty on all charges. Thank you.
Thank you, Ms. Williams. Mr. Evans.
Thank you, Judge. It's good to see y'all again. This is the last time you're going to have to hear from me. And as I see all of your faces, I know that's something you're looking forward to. And that's okay. I know that you all want to get back to your lives. And I can tell you on behalf of Mr. Johnson that your attention during this trial is greatly appreciated. What you've had to set aside in order to provide this service, I have no doubt that the court, and Mr. Hagerman, Ms. Iris, all of us agree you're indebted to you for that. Because like I said in opening, this is important. And you're about to have to roll up your sleeves and go to work. And it's going to be a difficult job. This young man's fate is in your hands. The concept of justice, right? We talked about that in Fort Dyer. We talked about that again in opening. Right? And it's in your hands. Meting out justice. And it's difficult because what you've heard is the tragedy of someone losing their life, of their family members not having that person in their life. And that is terrible, and the court will tell you, as terrible as that is, you can't consider that when you're determining guilt or innocence in this case. But it's heavy. And on the other hand, you have Mr. Johnson. This young man that you heard in the evidence is a young man, aspiring rapper. Wanted to make it as a rap artist. When you're going back through these exhibits, you're going to see a picture of him in front of the house on Bradley. Engaged in a music video, right, for his rap. Hat kicked to the side, kind of grin on his face, because that's what he wanted to do. And his fate is directly in your hands. And like we talked about, it's never justice to wrongfully convict someone. And so that determination that you're going to make beyond a reasonable doubt is the heaviest one, maybe one of the heaviest decisions you'll ever make. And you've had an opportunity to sit through the trial and hear the evidence, observe the witnesses, and you've been told, keep an open mind. And I hope you have. I'm sure you have. And not to talk about the case. You know, the thing that you've been listening to for days with people all around you that have going through the same thing, and then you have to be around them even when you're not here, and you can't talk about the elephant in the room. But today that changes. And not only are you allowed to talk about it, the judge has instructed you that you have to talk about it. And to engage in deliberations meaningfully, to listen to one another, to review the evidence that you've heard, to talk about it, and render a decision. But to the degree you're working together, what you never have to do is abandon your conscience. Now, I don't mean conscience like Cornelius Smith, that conscience. Because I don't think he really meant that when you heard from him. He said, oh, the reason I decided to tell the truth is I got a conscience. And we all know that's not the type of thing you're dealing with. You take that more seriously. You mean it. He didn't. You've heard a lot of concepts, you know, the terms of art and the law, the burden of proof, presumption of innocence. And when we started this, I told you, Mr. Johnson sits before you innocent. And I'm again telling you today, after the state has closed its proof, he remains that way. He didn't kill Adolph Horton Jr. He didn't conspire to kill Adolph Horton Jr. And he wasn't the man holding the pistol in the Makita video. And it's going to be up to you to decide that, to watch those videos. Watch them closely. They want to talk about those videos, and I'm encouraging you to study them. Give them a close look. The state doesn't want to acknowledge what I told you in opening, and that is similar. It doesn't mean the same. Plenty of people have gray sweatpants, black shoes with white soles, black hoodies. And as we learned through the proof, in Memphis especially, and elsewhere, Bass Pro has. You can look at it, if we had a window, you could look at it and you could see the Bass Pro, which is the pyramid here. You also heard testimony about it being a fad at that point in time. Famous rappers wearing it. Other famous artists. I think I mentioned Gwen Stefani wearing Bass Pro. One rapper has a signature Bass Pro hat. You heard from one of the detectives that they even interviewed someone who gave them a potential suspect that wasn't Mr. Johnson and said that person always wore a Bass Pro hat. You have to consider that. And then you have Sergeant Dabney, who, for the first time, and I think he acknowledged this, sitting on the stand, says, I think those underwear are the same. They're both blue. You look at the underwear from Tulane Apartments, you look back at the Makita video, those are the same underwear. Look at it. Look at the still shots. And for yourself, determine, can you tell if those are the same? And as jurors, you get to make that call. You get to look at it for yourself and compare those. We've heard a lot about it's not 1981 anymore. And I agree. Right? You know, we got cameras, but like I told you in opening, what also has advanced tremendously since 1981 is the world of forensics. Right? Fingerprints, DNA, touch DNA. And you have to ask yourself, why is Justin Johnson's DNA nowhere in that car? There's DNA in that car. You heard a lot about they wiped it. Cornelius Smith said he wiped it. And we'll get to whether you believe that or not in a minute. Okay? But he says he wiped it. But he didn't. There's fingerprints on it. Kristen Garner's, Trayon Ingram's, and Cornelius Smith. There was DNA found.
Sorry for the air, guys. Let's get through it and get back. I love stuff like this.
I want you to believe that Mr. Johnson's running around in this Mercedes, and the reason that his prints aren't on it are because he's wearing gloves. And mind you, Cornelius Smith, when he said he wiped the car, never said he wiped the driver's side of the car. Okay? If you believe that. And they want you to believe Mr. Johnson's driving around this white Mercedes, including with his daughter. Look at those videos. You think he's not wearing gloves. And he's got a little girl in tow that would presumably be in that car with him. No DNA recovered. None. Now, during proof, it was interesting because they would show the Mercedes go into crosstown and the Mercedes leave crosstown, and they would show a video of Mr. Johnson getting out and walking in the building or walking out of the building. There is no video that shows Mr. Johnson in that Mercedes. And you heard they had a reel, right? The video was a reel when they're doing crosstown. And when I asked it, I think it was Detective or Sergeant Dabney, about there was surely other cars going in and out at this very time. And he said, yeah. But you have to ask yourself, was Justin Johnson ever in that Mercedes? So let's go to Kristen Garner. Kristen Garner gets up here and tries to tell you that. He tries to say he didn't know the car was stolen. Trayon was driving around in the car. And at first, he acts like, even under questioning from Mr. Hagerman, that he wasn't even present when the car was exchanged, because he tries to say, well, Trayon told him. And if you recall, Mr. Hagerman had to kind of go back at him. I think he said something like, I can't tell you that. And then he eventually started answering some questions. You also remember that this is the same guy that went into law enforcement and said, I've never been in that car. I don't know a guy named Justin Johnson other than on Instagram. He's a rapper. And then suddenly, he starts evolving through the story. Still lying to law enforcement. He even looks at a video of himself, right, pumping gas, and goes, that's not me in the video. And he's like, okay, it's me. But they're trying to tell you Justin Johnson's at the Valero gas station, right, when he's pumping gas. Where is he? Now they want you to believe that this shadowy figure up in the right, top corner was Justin Johnson. And that he was the other passenger in the Infinity, but you can't really make out who he is. You have to rely on Kristen Garner. That's what you have to rely on. And we talked a little bit about, proof beyond a reasonable doubt. And I said one of the ways that you could use to kind of understand it is proof so convincing that you would not hesitate to rely upon it in making the most important decisions of your life. And it's really simple, right? You look there and you go, would I trust Kristen Gardner with anything? If he told me something, would I believe it? The answer is no. Because the more he talked, right, the more you realize he and Trayon are in the Mercedes. They're driving around with a Draco rifle, assault rifle. The same one described as being held by Cornelius Smith in the shooting of Adolph Thornton Jr. Their prints are in the car. He says they have, he said, a ton of guns in that car. And then he starts talking about how he's related to Dolph, and they were trying to dump the car before, right? And he's reaching out to Dolph's people to try to get rid of a car, which is the reason why after this happened, immediately, day after, he's calling Trayon going, my name's in this. My name's in this. Why would his name be? And B, why couldn't he just say, I don't have anything to do with this? And at Valero, you do see Trayon Ingram and Kristen. They're there front and center. Now, there's been a lot of talk about the phone and location. And in the state's argument just now, you heard her saying what the expert said, with a phone using, a tower that could be and he said could be. He said was in the service area of the Valero gas station. Or then he said, I didn't do any drive testing, so I can't say what the coverage area would have been, right? And when you're looking at his slides, you've got that really thick PowerPoint exhibit. You'll be able to look at it. And you notice, right, that you're going to notice that the pictures are all really small. They're really zoomed in on the map. And he's talking about, like, this, do you think this is thorough? This is thorough. I mean, he's going through all these calls. Look at what he's doing. I mean, but then you have to ask yourself, well, what happens if you expand the map? And then you realize, and this is the exhibit I entered, you realize he's not even counting all the data and calls, because when you show what he left out at 12:23, right, at the time immediately after Adolph Thornton Jr. was shot, there are several towers that Mr. Johnson's phone gets off of that are, one's 3 miles away in one direction. The other one is 3.2 miles away down by the Memphis airport. And then he has to go, I left those out. Not a really good explanation for why, right? Important. When there are a group of fine people that are looking to find the truth and have to make this decision and need to evaluate the accuracy of what he's telling you. And then you realize that when you talk about coverage areas and where things are in relation to these phones, somebody could be anywhere in a 3-mile radius, any direction. And then you have to go, what does it show us? How did that help? How does that make you any more certain of someone's presumed location at a given point in time? Because he said it's not an exact science, and I'm not here to tell you that I can pinpoint where he is. And I didn't do drive testing, and I don't know. The next available tower is what a cell phone normally would look for, but also I can't even tell you if the towers were down at the time. That could make a difference. That could put you further out. I couldn't tell you if they were down for maintenance, if they were overburdened. And he said, look, if the tower's real busy, it'll direct you to the next tower. But what it doesn't establish is that Justin Johnson was involved in the conspiracy to kill Adolph Thornton. It doesn't establish that he killed Adolph Thornton or possessed a firearm. Now, a little bit about conspiracy and some more of the facts as you heard them from some of the other witnesses. Now, I have to take a little bit of an issue with the state on something that was said during their initial argument. And that is this. There was no evidence at all that Justin Johnson was present for any meetings discussing this hit. What Cornelius Smith said was he met with Hernandez Govan and Jook, and Justin Johnson was not there. And then he said he met with Hernandez Govan and others on another occasion to discuss it, and Justin Johnson was not there. So to suggest that he was present and agreed, where's the agreement? He wasn't there. Now, get to Mr. Smith. The court has already instructed you about accomplice testimony and is already warning you that when you're considering that, you have to use caution. Now, you also have to apply the credibility factors that are in the jury instructions, but they're not an exhaustive list, right? Like,
None. Cashmere's so soft, it could give anyone a sore side.
The best things in life never change. They just get better, like Hardee's original bag.
All right, we're back, guys. Oh, why is this frozen? Okay, we're live. Why is it doing that? Okay, we're actually live, guys. Give it a couple seconds. There's something going on here. Come on. Something going on their end because we're streaming live. See, they were tired of hearing your ass, sir. I just told your ass to sit down. Now you done messed up the live. Oh my God. Okay, let's see if it comes back up. Let's give it a second. Yikes. Okay, it's doing something. Looks like they're trying to fix it, you guys. Give it a second. Ooh, child. Just told him to sit down. And messed up the whole damn show. All right, guys, be patient. Let's see what they do. Hopefully they can fix it because I want to hear the rest of this. This is interesting. Oh. All right, people, come on, fix it now. Hopefully when they come back, he'll be sitting down somewhere so he don't mess it up again. Come on, come on. It was getting to the good part too, wasn't it? Oh, let's see. Oops, something's happening. Okay, it's coming back because I'm watching on my phone in there. So we're back in like a couple seconds. All right, right after this, then it's coming. Boom, we're back. Yay.
At the time he was giving all this information, it made him valuable to come in here and talk. He thought he was getting out. That's when those letters are going out. Those letters are going out, and he thinks he's getting out because he's got the lawyer, they got the cooperator from Ali Bobo to walk. And that's the type of thing you have to remember when you're assessing whether you can rely upon Cornelius Smith and anything that he said. The guy that sat in that chair, and he was asked by Mr. Hagerman, when you killed Adolph Thornton, what did you feel? And like it was nothing, said, I didn't feel anything. Let's try to get paid. And that's the guy that they want to put in front of you and say, believe it. You know, he went and talked about exchanging money, right? Getting $800, right? At one point said, do you find people that he got that Mr. Johnson somehow came back into town and he talked on the phone with him and brought $500. And then some other time, some other guy in a Chrysler 300 showed up and provided money to his girlfriend. Well, two things. One, that's not what Mr. Smith originally said to law enforcement. He said that Chrysler 300 came twice. And then Mr. Justin Johnson had wasn't anywhere inside. Well, and what do you know about the Chrysler 300? Jamarcus Johnson, right? Did Jamarcus Johnson say when he was here in front of you, did you ever hear the state ask him, did you deliver the money? Is part of you being involved in helping Mr. Johnson? Did you deliver money for him? I mean, he asked about the email, or the text rather, about Cornelius emailing Justin's phone and saying, essentially, I need money for the birthday party. That's because Cornelius Smith is lying from start to finish. And then for the first time ever, here in court, he says he wiped the card out. Who's in contact? Who's in contact with Govan? According to Mr. Smith. Mr. Smith. Who's not in contact with Govan? Mr. Johnson. Did you hear anything about that? Now, when you go back in the jury room, you're going to be reviewing, obviously, these videos. And one of the things that you have to kind of ask yourself is timing. When you see Mr. Johnson in the elevator with his little girl leaving Crosstown that morning. And of course, you know there's going to be one exhibit that's the reel where the state had on it 11:51 in the morning. And then, of course, Mr. Hagerman came in, acknowledged the mistake to say that wasn't the right time. And put an officer on the stand, the lieutenant, to talk about getting access to the time, how he got the timestamp. But what that shows you is this. They don't know what time it was that day on that video. They don't know. I mean, mistakes get made. I'm not here to suggest that they don't. But you have to ask yourself, okay, the mistake got made, and then there's a timestamp. Okay, we want to put the timestamp one in. That seems like the logical choice. But then you have to listen to the lieutenant, right? And go, Lieutenant, what did you do to check and confirm that these were accurate times? Well, I looked at the live feed when I was in there. I had to have a technician, it's a computer. I don't understand it. But when I was there, I looked up at the screen and it appeared to be the right date and time. But not one person, you didn't hear from anybody that could say, that was confirmed, that's accurate, nothing happened with the system beforehand. And you even heard him say, it is not uncommon at all to pull surveillance cameras that have inaccurate date and times. Because you have to ask yourself about timing. You have to ask yourself about timing of leaving Crosstown, Mr. Johnson presumably going all the way to Whitehaven, if he's in that Mercedes and dropping his daughter off, right? And he said 20 minutes, something like that. Then he's supposedly driving all the way back to Wild Rose, 20 minutes, thereabouts, to pick up Cornelia Smith. They got to leave, then turn around and go to Bradley and go back to the white truck, right? And then get out and be in front of the Makita Cookie at 12:21. Now, that part of common sense and your everyday experiences, what does that tell you about going one place to the other, right? Takes longer, right? If you're stopping places, if you have to park, you're presumably dropping a child off, there's going to be some kind of a exchange of a child, maybe a discussion with a person, and you build all that in. That's a lot of time. And I would submit to you that one of the reasons that became an issue is about correcting that time is when the state realized that I was asking questions of that witness and asking him how long it would take to get from point A to point B to here to here to here. Because when you do the math and it's 11:51, it doesn't work. It doesn't work. And all this about Bradley, even the exchange of the Mercedes for the Infiniti, the dropping of the Mercedes at Bradley and picking up the SUV, whether somebody cleaned the Mercedes or didn't, who moved their Mercedes to the backyard, all of that, according to Cornelius Smith, should have been captured on Hernandez Govan's home security system. Right? He said Govan had a security system directly facing Bradley because that's why when he decided that he was going to go wipe the car down, either the day it happened or the day after, he couldn't quite remember, he texted Govan and said he was coming through there because he didn't want Govan to mistake him for somebody trying to come up on him. I asked Detective or Sergeant Dabney, did y'all canvass? Yes, we canvassed the neighborhood. You know, he didn't do it personally, but he would have presumed they would have talked to everybody, including Hernandez Govan. Right? We don't necessarily know if they did or didn't. We didn't get to hear from Mr. Govan. You know, I asked Detective Browning if he was aware of any video from there. No. But if Cornelius Smith, right, is this person that's telling you the truth, because the truth doesn't change, then the fact that there were videos would have been known as early as March of 22, when he was meeting with law enforcement. And you know, I'm not saying law enforcement doesn't want to find out who did this. They would have absolutely went and looked. But we don't know. We don't know. And there's a lot that you should know that you don't. Because there's a material witness that should have been called by the state that wasn't called. Hernandez Govan. And maybe some of you sat through this and thought, I want to hear what he has to say. And when I told you in the opening statement, I said, it's important, right? For you to weigh out and be able, as part of your duty as jurors, to be able to compare those two testimonies together. I'm sure some of you were thinking, yeah, that would make sense. I know we talked about that in voir dire, about getting two people to talk to kind of differentiate. You know, some of you that may have been a teacher, talking about that is one of the ways that you try to figure out who's telling the truth, who isn't. But you weren't able to do that. You weren't able to do that. You were deprived of that. And to be clear, as you heard about Hernandez Govan, he was cooperating in this investigation. He met with law enforcement on at least 2 occasions pursuant to a proffer agreement, which meant he was allowed to go in and give information and not have his words used against him later. I don't have the ability to make good on a proffer letter. Only the state does. I don't have the ability to wave a magic wand and give him a reduced sentence if he comes in and testifies for me. So he's to my exclusion. He's to Mr. Johnson's exclusion, and ultimately to your exclusion. And if this is a truth-seeking function, why didn't the state call? And it is. Your job is to find the truth of the matter. And ultimately to go, did they prove their case or not? But you were deprived of that. And the judge instructed you about a jury instruction. And that's the law. That's part of all the different things she told you. This is as important as any of them. And the law states that it creates an inference that the testimony of that witness, Govan, would have been unfavorable to the state. Now, it's up to you to decide whether or not he was unavailable, a material witness, and whether or not there should be the inference. But you're allowed to make that inference in here. And unfavorable, I would tell you, unfavorable to the state means favorable to Mr. Johnson. And knowing that, can you really render a verdict of guilty and have your mind rest easy? And not walk away and go, I just don't know if I did the right thing. Knowing that there was information out there that could have been presented to you and wasn't, that would have been favorable to Mr. Johnson, that I couldn't give you. Can you be morally certain in that instance? In order to be convinced beyond a reasonable doubt that Mr. Johnson is the one in that Nikita video, you have to consider everything. You have to consider what you heard. And you have to go, what I heard from Kristen Garner and Cornelius Smith, was that so convincing that I wouldn't hesitate to rely upon it in making those most important decisions in your own life? Will my mind rest easy if I convict this young man based on their word in conjunction with that video and the other video and what you didn't hear? The answer is no. When you examine your conscience back there, after you've taken the time to deliberate, I think you'll find the answer is no. Two things I want you to remember, and I'm wrapping up.
I'm still talking.
The way the burden of proof works. You've heard this statement, right? They ain't got nothing to prove. You may say that to somebody. I ain't got nothing to prove here. Justin Johnson, he doesn't have anything to prove here. They do. And we've all heard the term benefit of the doubt. Everybody likes to give somebody the benefit of the doubt. You are legally prohibited from giving the state the benefit of the doubt. You can't carry their water for them. Again, I appreciate it. This is, as I said, last time I get to speak to you. The state's going to get one more opportunity to talk to you this morning. They get the last word. That's how the system's set up. But it has been my honor to represent Mr. Johnson in this case. It's been my honor to present this case before you all. And thank you so much.
Thank you, Mr. Chairman.
We started this with a little Memphis talk. Those cookies are fire. That's how we started it. A little more Memphis talk. What y'all even talking about? What y'all even talking about? A missing witness? Fernandez Gomez? A missing witness? Fernandez Gomez? Absent material witness. And the defense wants to say that is Hernandez Gomez? What do we know about Hernandez Gomez? He's a defendant in the case. He is charged with murder and conspiracy to murder. Whether it's from television or whether it's in black and white at the bottom of that same instruction, a defendant has the right not to testify and incriminate himself. He is a defendant. He is not a missing witness. That would be insane. I could willy-nilly just start calling every defendant. And they just have to come in here. That's fine. That's crazy. It doesn't even work like that on television. It doesn't even work like that in black and white in front of you. That would be insanity, and that wouldn't be a legal system where you had a Fifth Amendment right. That would be an inquisition, actually what they used to call it, where you didn't have that right not to come to court. So the idea that the defense would call a defendant who's charged with this crime an absent witness shows you how desperate it is. And then we'll talk about things in isolation. Look at Kirsten Gardner. I'm sure he knew that car was stolen. I'm sure he did too. Well, then how can you believe it? Or look at Cornelius Smith. I'm sure it's not his conscience that made him talk. I'm sure it's not either. He talked because he's caught. So don't believe him. Somebody made a mistake on one slide about the time, so it was corrected. So we can't believe video. You know, there's a word that actually exists because it's a thing. It's corroboration. It's corroboration is what they call it. Like, can you look at something somebody's saying and compare it to something else and then determine whether or not that person's telling the truth about it? Because that's how we should judge stuff. Did Kirsten Gardner know the car was stolen? I bet he did. Does he think Treon Ingram actually paid for it because of something? No, we didn't pay for the car. They're riding around with guns in a stolen car, and they're trading it with their buddy, Mr. Johnson. But how do we know that? Corroboration. Is there evidence that shows us that? Well, there's the Valero video, which shows something strange. Shows something strange. Shows Kirsten come up in the car and somebody else get in and drive off. Strange. Another little piece of corroboration, where's Justin Johnson's phone at the time? Well, in the area of the Valero station. Can you say it's in the parking lot? No, you can't. But it's in the Valero, in the vicinity of the Valero station. But my God, is there something else? Yeah. And this is what is ignored throughout the entire talk we just heard. We don't just have towers. We just don't have cell phone towers. We don't just have a Valero video. We just don't have a Haven Court video. We don't just have a Crosstown video. We don't just have a defendant who's like, When it's Smith, I'm guilty and so is he, that's us two in the parking lot shooting him. Look at Justin Johnson's actual phone. We got his actual phone. In this case, it's been over so many times. Things that happen that are actually really dramatic just sort of happen. Because as soon as we saw the video of the Makeda shooting, as soon as you see the video of Crosstown of him leaving in the exact same outfit, in the white Mercedes, case is over. But we keep going. As soon as you hear from a co-defendant who's like, that's me in the parking lot shooting Dolph, I'm going to prison, and Justin Johnson's the guy next to me doing it, case is over. As soon as you see the Haven Court video, 40 minutes after the shooting of the two shooters and his cousin, case is over. But then things kept on happening. That if you didn't have all that proof, it would have even been more dramatic, or would have been dramatic. When they happened, I would see in your eyes a little thing, a little twinkle. We have his phone. And the night before, we have a text. The night before the homicide, we have a text. From who? Treon Ingram. To who? Justin Johnson. Sending him what? A picture of the white Mercedes. What do we have next? Another text. Justin Johnson. Treon Ingram. Dropping his location. Bradley. Kissed and said. They met on Bradley. Then they drove to Valera. And they switched cars. That's corroboration. So do you have to be able to trust Kissing Gardner with the keys to your car? Of course not. You think I trust Kissing Gardner with the keys to my car? But do I know he's telling the truth about this? Well, yeah, I do. Because it's on video at Valero. It's documented in his phone with literal pictures and locations. This is plain and simple. Do I have to believe that Cornelius Smith is talking because of pains of conscience? No. No. He's talking because he got a call. Is he hoping that the truth will help him? Absolutely. He's hoping that the truth will help him. Is he going to prison after this? Absolutely. He's going to prison after this. Is there anything about his testimony, like Kissing Gardner's, that we can corroborate? Oh my goodness. What's the first thing he tells us about that day? Justin Johnson calls me. I think I missed a call, and then I get a second one. And what do we got? Justin Johnson's phone. You can delete your call logs, which he did from that day, but they're still in the phone. And what do you know? 2 calls to Cornelius Smith from him right before he comes and picks him up at Lamont Steps. That's corroboration. What does Smith tell us? We go to Bradley directly after the shooting, but dump the cars. Dump the cars is important. Because here's another little, real tricky truth test. Justin's driving the white Mercedes. See it in the video, of course. When he testifies to it. He says, we drive to Bradley. He hands me the keys to the Expedition. I jump out of the car. I get in the Expedition driving while Justin parks the car in the driveway there on the front. Well, we know the white Expedition is also Justin's car. They're saying it across town for testimony. What do we see at Haven Court? Cornelius says, from there we end up going to Justin's cousin's apartment Used to be called Two Lanes, Gospel Gardens, the address on Haven Court. We see the white expedition arrive. And who's driving? The white expedition. Justin's car. Who's driving? The dude with the messed up shoulder and the messed up shirt. Cornelius Smith. I mean, how do you make that up? How do you make that up? They pull up at Haven Court with Cornelius Smith driving and Justin in the passenger seat, just like it had to happen, just like Cornelius Smith told you when he testified. We do the shooting. Justin's driving a white Mercedes. He hands me the keys to the expedition. He goes to Bradley. I jump out. I get in the driver's seat of the expedition. Justin parks the Mercedes, jumps in, Haven Court. And what do you know? That's what we see. What do you know? If you're lying, that detail is almost impossible to account for. Corroboration. We plainly see in the video, Haven Court. We plainly see them go inside. We plainly see Justin Johnson come out, meet this character in the Dodge Challenger, get some other clothes, get some bags, go in. We plainly see the Chevy Trax car, Angela Arnold, pick up Cornelius. We plainly see Justin get in his car, the expedition, and the two pull out. His testimony is corroborated over and over and over. And that's so incredibly important as we can try this. That's how we make decisions. Corroboration. That's why we have evidence. That's why we don't just call one witness and say it's over with. We put evidence in front of you. And one of those moments when this trial was just over again for the 5th time was when we were showing the slide from his phone, from Justin's phone. Cornelius says right after the shooting, Justin calls and FaceTimes with somebody. He says it's a big joke. The guy that put the money down. It's number 2 at C and G. The guy that put hits on the other artists too. Cornelius says it's FaceTime. Spelling out Dolph with your hands. And what do we find in Justin's phone? I mean, they'll read the stuff all day long. He did. Whole day. November 17th. They'll read it all day long, but it's still in there. A call and FaceTime interaction with him. Justin Johnson with Big Joke. With Big Joke. Cornelius tells you. And there you see it in black and white. It's not 1981. That's true. Called on camera and everything else, but you're also walking around your pocket with a phone that you can delete a call on, but it's still there. The times you called Cornelius Smith that morning, still there. The time when you called and then FaceTime with Big Joke right after the murder of Dolph, still there. The videos from Haven Court that show you arriving, still there. The videos of Haven Court that see you changing clothes. Did he have enough time to do it? He didn't have enough time to do it. He left crossing at 10:51. He had over an hour and a half to go drop off his kid 20 minutes away and drive 10 minutes. Total trip probably take you 30 or 40 minutes. Yeah, you have enough time to do it. We saw him do it. Memphis Talk, all the times. All the times. Before the murder, we see him at Crosstown in the murder outfit. Similar clothing? No. Identical clothing. Patch on the legs, Bass Pro hat, everything. before the murder? The Mercedes. Similar Mercedes? No. Back end damage, just like we saw in the video. During the murder, again, caught on video, white Mercedes, back end damage, the exact same clothing across town. Looks like him. Right-handed like him. Gloved up, like Cornelius said. Driving away from the murder. Who you calling, who you texting, who you Caught before, caught during, and then caught after. At Haven Court. Video of them arriving and leaving. Caught before, during, and after. That's called being caught all the times. All the times. He is literally caught before, during, and after. Caught all the times. And then what does he do? Then what do we know? Another Memphis phrase. Get on down. Get on down. Across town, the last video. Packing my suitcases to head out of town. Packing my suitcases to head out of town and get on down. Like the police tell us, a man, not just in Memphis, well beyond Memphis. As Jamarcus tells us, he's going in and out of town. As Jamarcus tells us, he sees pictures on social media, Rolls Royce, stacks of money. Get out of town, get on down. The crime has been committed. Dolph has been killed, and we literally see him at the elevator with his suitcases getting on down. Flight can create an inference of guilt. Well, yeah. This case was over when you saw the videos. This case was over when you heard from the co-defendant. This case was over when you saw him at crosstown with the suitcases leaving, knowing that the manhunt was coming and he was out of town and leaving. Really. Really. Now it's time for us to get on down, but we don't get on down by fleeing. We don't get on down by hiding. We don't get on down with pictures of Rolls Royces, stacks of money. We get on down by doing what's right and doing our jobs and looking at the evidence, the witnesses, the corroboration, and applying the law to those things. We get on down by doing justice. We get on down by saying you are called all the times. You are called all the times and you're guilty of all the things. Conspiracy to commit murder? I just heard, okay, let's at least cut him a break on the conspiracy to commit murder, because man, he wasn't there for at least like one of these meetings with Big Joe or something. That's what I just heard. Let's cut him a little break on the conspiracy to murder, because he's not at this meeting with, Big Joe, Govan, Cornelius. So let's cut him a little break on that. That's what I heard. Let's cut him a little break on that. There's no requirement in the law that every conspirator have to be at every single meeting with each other. There has to be an agreement, an understanding. And there was clearly an understanding. Big Jook is going to pay money to take out PRE artists, and at the top of that chain is Dolph. Now, does he demonstrate any understanding of that? Is there anything he does that shows he's part of this like understanding that this is going to happen? Yeah. He literally shows up with gloves and guns, has a white Mercedes he gets from Treon, has Cornelius driving next to him, and they drive and go do it. So the idea that, okay, he committed the murder, but give him a break, no. He's guilty of the conspiracy just like they're all guilty of the conspiracy. And of course he's guilty of the murder because we watched it on video. Last short thing. Just one minute. Just 1 minute. You too real. Dolph, you too real. He rapped about what he calls come up. What he saw in the neighborhoods, what he saw in his family, growing up. Too real. He rapped about people that he had a rivalry with. Too real. Off too real. Included distance of dangerous people like Big Chuck. You're too real. Too real. Too real. Last moments of his life, last seconds of his life, almost videotaped 30 seconds. You're too real. Dies on the floor in the neighborhood cookie store in Orange Mill. You're too real. Your family misses you. Erica and Mia, kids. You too real. This is real. This is too real. And when the killer, 1 for 2, is caught on video, all the times, you even watch him get on down. It's time for us to be real. And we don't need Memphis talk for that. It's called just do what's right. It's as simple as that. Just do what's right. Anita Smith and Justin Johnson killed Adolph Thornton Jr. November 17th. We watched it happen. Anita Smith, Justin Johnson, and this Govan and Jill, they all conspired to have it done. And it was done. November 17th, 2021. And as he did, he was already convicted of felon. He should be found guilty of all counts. We do what's right. That's how we do. Guilty of conspiracy to commit murder, murder in the first degree, and convicted felon in possession of
I got a few more pages of the charge for me to you. Pick up on page 29. charged offense in the first count of the indictment is conspiracy to commit first-degree murder. The lesser included offenses in order of consideration from greatest to least are facilitation to wit, conspiracy to commit first-degree murder. When you retire to consider your verdict in the first count of the indictment, you will first inquire whether the defendant is guilty of conspiracy to commit first-degree murder as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of facilitation to wit, conspiracy to commit first-degree murder as charged and included in count 1. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of facilitation to wit, conspiracy to commit first-degree murder as charged and included in count 1 of the indictment. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offense as charged and included in the first count of the indictment under the law defined and explained to you, it is your duty to acquit him. Your verdict will be: we, the jury, found the defendant not guilty as to count 1. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. Count 2. The charged offense in the second count of the indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. You will next inquire whether the defendant is guilty of first-degree murder as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of first-degree murder as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, second-degree murder, as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of second-degree murder as charged and included in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, facilitation to wit, first-degree murder, as charged and included in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of facilitation to wit, first-degree murder, as charged in count 2 of the indictment. If you unanimously found the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense in order of consideration from greatest to least, as set forth on the previous page. If you find the defendant guilty of a lesser included offense, your verdict will be: we, the jury, found the defendant guilty of, as included in count 2 of the indictment. Insert a lesser offense in the blank. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the second count of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be: we, the jury, found the defendant not guilty as to count 2. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. Count 3. The charged offense in the third count of the indictment is convicted felon in possession of a firearm. There are no lesser included offenses. You will next inquire whether the defendant is guilty of convicted felon in possession of a firearm as charged in the third count of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: We, the jury, find defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the third count of the indictment under the law defined and explained to you, it is your duty to acquit him, and your verdict will be, we, the jury, find the defendant not guilty as to count 3. You are right to verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. When you retire to the jury room, you will first select one of your members as foreperson who will preside over your deliberations. When you have reached a verdict on a particular count, the foreperson will write your verdict as to each count on the outside of the jacket and sign his or her name to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and return to the court with verdicts that truth dictates and justice demands. All right, as I told you before, this is the official copy. Please refer to it. There's just been a couple of minor changes made, but nothing substantial, nothing substantive. Let's put it that way. A few typos I ran into, but other than that, please use yours, make notes on yours, refer to yours. But this is the official copy if there's any discrepancy. The jacket, please. You will have all of the exhibits to go back with you. Please look them over. If at some point you want to watch videos, please let us know. You have did you make the list? Is it?
It's been numbered as an exhibit now.
Okay, so it's with the exhibits. You have a clean laptop, so they can you get us a clean laptop so they can watch videos as they want to watch videos. Thank you. So you will be provided a laptop that's clean, so you can watch videos how you want to watch videos, and there will be a list accompanying the video to show you, to tell you, describe to you which video is which. That makes sense? Okay. So, is everybody in good shape to deliberate? You can ready to choose alternates. Everybody good to deliberate? I'm going to call three numbers. Once all three are called, the deputy will escort you back to get your belongings. And if the three of you could come back out here, because I have a few remarks for you. And then the rest of the jurors, the 12 of you that will be seated to deliberate, will go back and begin your deliberation. Okay. Juror number 18. Juror number 13. And juror number 12. You guys can look at these if you like. You can review these.
Oh, yes, sir.
Oh, no. Just make it a point to show you.
Yes, sir. Thank you.
Lunch should be here in a little while. Let me admonish you now. All 12 of you will deliberate at the same time. There should never be an opportunity where 2 or 3 over there eating and the rest of you are deliberating. You decide you're going to eat, everybody eat. You decide you're going to take a break, everybody take a break. When it's time to deliberate, everybody deliberate. Just let the deputy know that you're doing something different besides deliberating. Okay?
You guys, I'm starving. What are we doing for dinner tonight?
I decided what we had for dinner last week, so why don't you guys decide?
Pizza!
I just got french fries.
Sushi!
Feeling Claritin Clear is like
Jurors, you are excused.
Okay.
Court stands in recess.
Court stands in recess.
Kathy. We're still here, guys. They're muted, so we're waiting for them to say something, okay? Of course. Hmm. Just two.
DSG, only at Dick's.
Wix gives you the power of AI to build the website you need. With full business functionality and a design tailored
Looks like they're getting ready to come back, guys. Okay, give it just 1 second. All right, guys, we're still waiting. I see some people have dropped off. They're tired of the dead silence. I don't know why it's taking them so long to come back with the verdict. This looks like a cut and dry case right here. I mean, everything that they needed was in the videos and everything else. But we're what 2 hours, 45 minutes in. Hopefully they'll be back with their decision here in a few minutes and they can get this ball on the roll. Okay. So I'm waiting with you guys. All right. Thanks for all 48 still waiting. Whew. You guys can put in the chat what you guys think. Is he going to be guilty on all counts, or do you think they're going to just get him of some of the counts that they have him for? Do you think that he's guilty of what they're saying he's guilty of? Because his defense is that he's not guilty. You're trying to debunk that was him in the video and all this other stuff. He didn't have on the hat and all this other stuff. Well, y'all can put in the chat. What do you guys think? What do y'all think? Uh-oh, so there go the judge coming back. Looks like the judge was just coming back. Let's see what's getting ready to happen. Okay, so...
The Tonight Show, you can't turn the fun off. The Tonight Show's delivered laugh out loud fun for 10 years strong. That kid's going all the way!
You have a very honest face.
And Jimmy Fallon makes the job look easy. Got my top pants on. Weeknights.
Let's see what they're saying over here in the chat, because they have a chat going over here, a live chat. Let's see what they're saying. They said that she needs to bring her finesse 2 times. Look, oh Lord, they going off. Okay. They said the jury is eating and talking it over. They will come back with a verdict soon on all guilty of all charges. They said the Gotti got juke whacked to avoid him from potentially being ratted out. Said that will Gotti stand trial later? Will CMG be dissolved? That's what people are asking. Somebody else is saying it's an open and shut case. What's taking them so long? Right. Said the thug was way too sloppy with how he moved. Said he even rapped about his crimes, and he sure did. That's so stupid. Said the guy got, oh, did it? Yeah, they already said that. So you guys can see what they're saying in the live chat in terms of what they think as well for this particular case. You guys are welcome to put what you feel in the case as well. Everybody's chiming in. It says South Memphis don't play. They sure don't. They going off in the chat. And it says get Rico. Yep, they probably gonna have a Rico. Said it was someone pleasing. That's so crazy. They said the snitch is gonna get less time and get out, and the streets gonna handle him. That's what somebody's saying in the chat. They said give life for the snitch. It says that he is the one with the Draco. Says that he's making sure that his guys get it too. I don't know. We'll see. It's about to come up. It's about to come up. Let's see. What you guys think? It shouldn't take them that long to get back with a deliberation, though. My goodness. Somebody said straight drop is going to prison. We about to see in a minute. We about to see. These guys be thinking this stuff they see in these videos be real life. They don't understand. Sitting in prison for life like that ain't no joke. You waste your whole life over some mess. And then these new age guys, they be sitting here singing about and rapping about crimes that they commit, which is so stupid. I mean, why you gonna put a mask on and put gloves on to cover up the crime and then get on a song and rap about what you did? That's the dumbest thing ever. I don't ever understand that. I never understand that. You might as well just walk up there with no mask or no gloves on and just do what you're gonna do. You're gonna get caught anyway. They did all that, got rid of phones and weapons and left town and still got caught. That's crazy. Y'all see what they're saying in the chat? They're going off in the chat. Yeah, I've been saying, I see somebody, Miss Pat B said that they should investigate Makita's cookies. I said the same thing because I feel like that dad knows something because he left and changed clothes and something with his car too. I saw. So I think that dad knows something, and I think that daughter with the dreadlocks, the kind of heavy set one, I think she knows something because she's involved and or connected with CMG Yo Gotti and them. I saw that on a few videos because she was an exotic dancer and she was repping CMG in her video. So I was like, I don't know, because they're saying that back door was open and what she was saying is the door is always closed and locked. So why this particular day was it unlocked? It gives that you were trying to be an accessory to a crime, allegedly, is what it gives me. But I don't know why they're not investigating them. I don't know. And her story changed a few times in the videos as well. I was like, why they didn't catch that with her story steady changing like that? I didn't understand it. Oh, that's a long break. Still nothing. Wow. I didn't anticipate this one being as long. I'm going into 3 hours. Oh my God. Okay. Say the streets here in Memphis has been hot, and Pete says that a lot of people have blocked lies behind the message that they need to get everybody that is involved in this mess. I agree. It says that the Makita's owner pulled up right after Dolph got unalived. Says I thought something was up with that. Yeah, that looks suspicious. Says exactly that they said that the pow pow was from the back of the counter. They did say that. They did say that. We're gonna see what's going on though. You guys see those comments coming in from the live chat on there? Yeah, I think more people than they caught are involved. And they definitely need to get them. Definitely. What is it? 139. He doesn't even, the guy, what's the name, Justin Johnson, he don't even look worried. I mean, if I'm potentially going to be spending life in prison with all those counts, he don't even have like a worry at all on his face. He just looking like, oh well. And you're a felon, you weren't even supposed to have a weapon, so he don't look nervous at all. He don't look like he care that he's gonna be spending the rest of his life in prison, and he's young. I smell a Rico coming and by CMG. Yeah.
The 11th annual Foo Foo Fest. Start planning today.
Y'all know it's bad when the ads are starting to become more interesting because we're waiting. Let's skip. And still waiting. They said pray for Justina. They calling him Justina. Oh God. Justina don't look like he want no prayers. Justina look like he's okay. He look like he's okay. He look like he's just ready to get it over with because he's bored. Mm-mm-mm. Let's see. Oh boy. Some of these people in the chat are just so stupid. Said that Dolph wasn't a good rapper anyway. What does that have to do with him not being here no more? That's so stupid. I don't be understanding people's thought process sometimes when they be saying stuff like you literally typed that. You took time to type that in the chat. Who cares if his rap skills were good in your eyes? This man is not here anymore and he's got kids. That's so stupid. Said that Justina wasn't praying when he took him out. Yeah, he wasn't. He sure wasn't. I can't even have any sympathy for these guys. And it was all for a small amount of money. I'm pretty sure none of them have any more. Okay, we're still waiting. Somebody said, I think the judge told them they could also take a break, so they're going to deliberate and take a break. My Lord, we're going to be here all day. We are going to be here all day. Let's see. Said I think it's far from over. They said I think it's political movement. Political involvement too. It could be. I hope not. Do we have anybody from Memphis in the chat, you guys? I think I saw one person say they were from Memphis. How many people do we have in the chat from Memphis, you guys? Miss Pat, be you from Memphis? Yeah, the good old days are definitely gone. The good old days are definitely gone. Somebody said Yo Gotti ain't going down. His name has never been mentioned in anything. That don't mean that it can't be. That does not mean that it cannot be mentioned. Yeah, they can always spin the block and get him. I mean, I've seen cases where they go 20 and 30 years and come back and get people for something that they uncover later on. So that does not mean that he's out of the woods at all. That just means he got away with it for now. We're talking about Yo Gotti. That means he just got away with it for now. But I've seen them come back and get people. So he could very well be found guilty. Don't he own a restaurant, or his mother owns a restaurant in Memphis? You guys let me know. That's what I was hearing. Doesn't Yo Gotti's mom or Yo Gotti own a restaurant in Memphis that you guys know about if you live in Memphis? So there has been a lot of people alive here in Memphis behind this stuff. Oh yeah. Says that yes, the restaurant name is Prego. Okay. Is that his restaurant or his mom's restaurant? Because I was hearing that it was his mom's restaurant. Thank you guys for hanging in there. We're back up to 73 people again. See, a few people fell off. It's a lot of waiting. Hopefully they get here soon so we can hear something. Thanks so much, Nana75, for supporting the channel. I appreciate it. Okay, you guys, my apologies for all this dead silence. Okay, we're all waiting for this verdict. Thank you guys all for coming over. We're watching live, so you guys know. It's kind of almost like it was when we were waiting to hear Diddy's verdict for if he was going to get bail or not, which I already felt like he was not, because I knew they were going to say he was a danger to society, at which he is. But we'll see what it's given. I don't know. I definitely think they're going to get him on all counts. That's what I think. Somebody in the chat saying life. Yes, I think all of them gonna find him guilty. Have you Miss Pat? Have you been to Makita's Cookies? They're saying that that's like some of the best cookies in town. There, have you guys been there? I don't think if I ever go to Memphis, I'm definitely not going there, because that don't sound like it's safe now.
We all deserve a place to call home. That's an amazing.
Skip that. Child. We're still waiting. Young Dolph. For those of you just joining, we are awaiting the verdict for Justin Johnson for day 4 of the Young Dolph unaliving trial, you guys. Okay, we're watching this from Fox 13 Memphis News. Okay, this is live. So for those of you that are just joining, feel free to put in the chat what you think, if you guys have been following this case, if you think that Justin Johnson will be found on all counts, at which he has many, for the death of young Dolph. Okay, so you guys let me know what y'all think. He said Makita's Cookies is in South Memphis. Yeah, the cousin pastor did have a lot. I saw that he had a lot of information. Yeah, I've been following this case since all of this stuff happened, and I was just like, wow. I couldn't believe something like that happened. I could not believe it. When I first saw it on the news, I said, oh no. Because I knew they tried to get him in LA, but they didn't get him. So I don't know. That's so sad. Still waiting. Okay. Let's put your super chat up. We always appreciate you guys supporting the channel. Thank you so much. Woo. This weather got me sleepy, y'all. It's raining here. Everybody still awake in the chat? I'm still here. I'm still here. I'm just working while I'm watching with you guys. Said nobody has heard from custom pastor since the wife aired him out. I'm gonna look it up. I'm gonna look it up to see what the custom pastor is up to, because he be online doing the most. Okay, he be online doing the most. So he does have a YouTube channel. I will definitely have to go see what he has going on, because he be over there going off. Okay, yeah. Yeah, they said that he's something else. It says that him and his wife used to have you tickled late night on the YouTube streets. Yeah, they are a mess. They are a mess. Thanks so much, Mary Brown from Hampton, VA. Yes, justice for young Dolph. I know that's right. Okay. Still waiting, still waiting. Said I'm still here. I'm going to wait. Yep, I'm waiting too, because I want to see what this is going to be. Yep. They said if he's able to get bail, his life in Memphis will not be long. I'm pretty sure they're going to probably try to do street justice, and I don't ever like to recommend that, but that's inevitable. You can't tell a person how to react when they're mad about a situation like that, because I know they said Dolph had a lot of people in Memphis that love him, and that rock for him, so, or rock with him rather. So that's going to be, that's going to be a hard one. And the sad thing is nobody wins in this situation. Like, you already lost Dolph, and then to turn around and for somebody to kind of take justice into their own hands and unalive somebody else. I mean, it's not a win-win situation. I mean, the person's not here anymore, but you still not bringing back the person that you love and that you miss, you know. So that's what they're doing now. That's why so many people have lost a life. Yeah. And then too, you got to think about people that they never even questioned, that may have seen something, that may know something, that may have been speaking like in the streets, because that happens too. Like, start telling people things that they may have seen or may have known about this case. They become a target as well, because they don't want to be ratted out. So they have to, you know, get rid of people in order to make people be quiet. So that's another issue that people may not understand. When you start pointing the finger at people, they don't want to be outed to say, hey, this person was involved in such and such. They don't want to be involved in that. So they're definitely going to try to, you know, do what they have to do in order to stay from under that radar. That's the crazy part. They said the guy that was keeping up Dolph's memorial at Makita's Cookie, oh, he wound up unalive too? Oh my. Says he did a lot here in Memphis for his Black people, and I love him forward and take, yeah, and thank him for that. Yeah. I know they say he did the turkey drive thing. He was actually on his way there to do the turkey drive when they wound up unaliving him. And that's so crazy that the girl that worked at Makita,
There are those who skip
was
dessert,
recording
but
him
when
right
Ghirardelli
outside
chocolate
of
chips make
Makita's
cookies
right
this
before that
irresistible,
incident happened. So my thing is, did
dessert
you go out there to run
simply
behind him to kind of
unskippable.
stall things? Because he was getting ready to get in his car and leave, y'all. Now that I think about it, he was getting ready to get in his truck and leave, and she kind of ran out behind him. I thought that was very weird, because they said he went there all the time. So why this day of all days did you feel the need to like stall him and put a camera in his face and like ask him questions like, do you like the cookies? I felt like she was trying to stall him and make him kind of be standing out front so the guys who were looking for him would be able to verify that it was him and that he was there. That's just what I think. I watched enough crime shows to kind of know how this stuff works. It just gives weird to me. Because they said every time that he came to Memphis that he loved those cookies, so he would always come there and patronize their business, like purchase cookies and stuff from them. So it's weird to me that this particular day when these guys are out on the look for him, that you would have him standing outside in front of Makita's, while he was getting ready, because he had the door open at his truck. It's a video out there. He had the door open. He was getting ready to get in his truck. He was eating the cookies. He was saying, "Oh, these cookies are good." I think it was chocolate chip, where he said was his favorite ones. I remember the video like it was yesterday. But she just kept asking him questions, and he just looked like he was ready to go. And I feel like maybe she might have been stalling him so that maybe these guys they could have drove by to see like, yeah, he's here, and then went ahead with their plot to do what they were going to do. That's just my theory. Because I keep saying, and then it's no coincidence where you saying that doors and stuff are always locked, and these boys ran up this alley through the back way, and coincidentally, that day of all days, that door is unlocked. Okay, and you guys let this man up. Well, I ain't gonna say y'all let him in because I don't know, but they come through the back like that. I just feel like it was a setup. I felt like Dolph was set up. That's how I feel. I feel like maybe he felt in his spirit that particular day that it was time for him to leave because something might be getting ready to happen. And it's weird that that she kind of kept him standing out there asking him stupid ass questions that he probably didn't damn feel like answering about no damn cookies. So that's how I feel. That's what I feel. Because he could have been gone had she not stalled him outside that cookie shop asking him, do he like the cookies? What's your favorite cookie? And all that. You already know that if he come in there every damn time he come to Memphis. I mean, right? Am I putting 20 on 10? I think about stuff like that. I'm just like, why are you asking me the same damn questions over and over? You know how I feel if I spend a bunch of money, because they say he buy them in bulk when he come there because he's not in town all the time. So he get enough cookies to take with him. So evidently he liked the cookies. So it's weird. I think those boys saw him standing out there talking to her and then she distracted him by videoing him. Okay, I think that was a distraction. What y'all think? Let's just worst case scenario. I think that the fact that she was recording him, worst case scenario was that she was trying to take his attention from looking around, because y'all know with him being who he is, he's probably every time he's out and about, he's going to be on alert, kind of looking around. So with her having the camera in his face and asking him questions, his attention was on her and not looking at the fact that maybe he was being stalked by these guys that were going to take him out. So he wasn't looking at somebody maybe driving by and like, hey, that's him. He's there. He's standing out there now, and went through with their plan to take him out. And I feel like she might know about it. And that's the sad part. I feel like she diverted the attention away from him, looking out for himself by recording him and doing that fake ass cookie interview. That's what I think. I feel like it's a setup. I see a lot of yeses in there. Said exactly, real, exactly. Yeah, that's how I feel. That's exactly. Yep. Wasn't that the day before it happened? I gotta go back and look at the video. But I do know he went there and got them damn cookies and she was sitting there. But I mean, even still, even if it was the day before, let's just, the worst case scenario, even if that was the day before they pow-powed him, they knew he was in town because he wasn't able to run in there right quick and get his cookies and run on back out of there. Because it looks like that's what he was planning to do. When she ran up out there, because he was already at his car with the door open. So had he been able to get in his car and skirt out, I mean, maybe they wouldn't have known that he was there because they were looking for him. So they didn't see him until the day of that they pow-powed him. So maybe he could have kept a low-key profile had that not happened. They probably saw him that day standing out there in front of that cookie shop. She probably was like, hey, he's here at the cookie shop. Matter of fact, if y'all want to verify it, I'm going to go out here and I'm going to video him so that you guys can see that he's standing out here. So he's looking at her, smiling and talking to her, not even probably seeing that they rolled by off that, because Makita's is right off of a main street, right? Let's just do worst case scenario, because I be watching a lot of crime shows. So it could have been that. Like she probably helped them verify that yes, he is in town. Yes, he is here at the cookie shop, or whatever. I don't know. So I'm gonna go back and look at some more of those videos because it's giving that, I feel like he was set up. I just feel like that. I feel like he was set up. That's just what I think. That's why I'm always, when I'm out and about, I'm always looking around and aware of myself when I'm out, because it don't take but a second for somebody to run up on you or anything. You just never know. People are crazy, and you don't have to do anything to anybody for them to do something crazy to you. You just be in the wrong place at the wrong time. So you definitely have to be like prayed up and alert when you be out, and I definitely do be. Like that's all the time. You say McCookie's is right off the it's right off the freeway. It says Lorenzo Gordon is going to jail for stealing PP loan. Who's Lorenzo Gordon? Who is that? Did I miss something? It says I'm going back and watch the videos too. I saved them all. Yeah, I think I got them saved somewhere, probably in my YouTube videos, I think. Okay, looks like we might be back. They're talking, but they're muted. So the judge is back. All right, come on back, Judge. Bring them on back. Let's get this verdict now. Let's get this verdict. Why the judge keep playing with us? Like she come back like they getting ready to start, and she disappear again. I feel like the guy that they only gave $800 to, I felt like he was definitely gonna speak up because he was mad about that damn money. I don't blame him. You promised to give me 10,000, you don't give me but 800, and you don't never give me my money. Like, yeah, I'm snitching. Say what you want to. Yes, we are definitely going to be talking. We are definitely going to be talking. They did him bad. Like, what you gonna do with $800? Not a damn thing. And run through that in one day. Yep. Town C says, I agree, Caramel is the setup. Yep. Yeah, they did play him like a fool. They really did. They really did. Still going, still going. So the guy got jiggle whacked to avoid him from potential. They're saying in the chat they think that Gotti got his own brother whacked off to keep him from. What? That don't make no sense. That don't make no sense. The Gotti got juke whacked to avoid him from potentially ratting. Says, will Gotti stand trial later? Will CMG face Rico? I don't know about that one. I do think that Big Juke's unaliving was definitely retaliation, though. I do think that. That I do think. I really think that was retaliation. This says, and now they are in jail, penniless. Right. Big time fools. Right. So the young Dolph had a lot of rental properties. He did. I heard about that. Okay. Oh yeah, go into Juke out. Okay. It's from Orange Mountain. Okay. Y'all got a lot of information in the chat. That's what's up. Okay, I see y'all been doing y'all homework and watching videos and stuff too. Shout out to those of you that's from Memphis. Y'all getting it right there up close and personal. They finally, did they get Makita's back open? Because I know that place was messed up with windows and stuff shattered. And I know the last time I saw pictures.
Reserve now to experience Chihuly this fall at Biltmore.
Kamala Harris knows what it's like to carry our children, our jobs, and our parents.
Ads. Still on their break. Okay. Thank you guys for hanging in there. Thank you guys for hanging in there. Now, if they have Diddy's trial and it kind of be like a live trial, you guys know I'm going to cover that, right? I'm definitely going to cover that. If that's a live trial with Diddy, and I'm hearing today that Diddy is set to testify in his own trial. We're going to talk about that later on in our pop-in video. But it said that Diddy's attorney has announced that Diddy will be testifying in his own trial, which I don't recommend that shit. But yeah, we're going to talk about it later. But I do not recommend it. That's why I keep saying there's something about this attorney. He might want to get another attorney. But if they definitely do a live, if they allow us to do it live, I will definitely be covering it and show it right here on my channel so that we can see what's going on, honey. That's going to be the trial of the century, like almost like OJ's trial. So I'll definitely be watching that. Ooh. Excuse me, guys. Yes, I'm here for it. Yeah, I'm definitely covering that. They said, and Makita's Cookies open up one in Texas. Oh, okay. It says, I always say when stuff happens like this, I said it is all worth it. In my opinion, he was taken out because he didn't pay. Makita's Cookie had a 25th anniversary yesterday, the day before here in Memphis. Oh, okay. They said they smell a Rico coming. Child, yeah. It's gonna definitely be a Rico. Okay, yeah. Ooh, that's a long break. Did they give them an hour knowing that we're on live? Did they give them people an hour knowing that this was live stream like this? My goodness. I'm gonna go through and edit all this dead air out. This long wait, I'm gonna have to edit this out because that's gonna be about damn near an hour. Right, so you know the courts don't care. It don't look like they do. It don't look like they care. Ooh. Let's see. So they might be back there eating lunch. That's what it's giving. I'm like, child. Yeah, I'm gonna have to edit this video up to get some of this dead air up out of it, child. But we just kind of sitting. I hope you two don't be tripping over that. I'm happy he's getting some justice. I know that. Because I was worried for a minute, like, are they going to find out who did this? Because before it wasn't nobody coming forward. I was like, oh, Lord, are they going to find out who did this? Yeah. Run through it in 5 seconds. Said run through it in 5 seconds, Rose Armstead said. Yep. We about to see here in a minute. If they get back. The judge must have been hungry because she hurried up and came back. She flew through her lunch. She tore through that lunch and came right on back. Those of you that live in Florida, are you guys experiencing any changes in your weather there? You guys? Just while we're waiting, are you guys experiencing any change in the weather there? Are you guys seeing maybe like a more rain and winds? Any damages so far? Okay, KB, are you in Florida? Says sunshine and light rain. Off and on, no damage. Great. Okay. Sounds good. So I said I'm down on it. St. Petersburg. Y'all okay in St. Petersburg? I see somebody from St. Petersburg, Florida. You guys okay in St. Petersburg? My son said he gonna go get in the bathtub if we get a storm. They teach him that at school. It's so funny. He said, "Mom, I'm going to get in the bathtub. If we have a hurricane, I'm gonna be in the bathtub." I said, "Oh, okay. Go on up in there then. Go right on up in there." Said, "Yes, you're okay." Okay. All right.
A new chapter unfolds in the biggest game of the year.
They say he ready. Justice for Dolph. That's right. Everybody still awake? Yeah, I'm working. I'm working and watching, guys. Working and watching. Y'all hear me doing all this clicking behind behind the scenes? Yeah, I'm working. Let's see. Hmm. Somebody said take Benzino. What? They said they better come correct with that verdict because Memphis gonna cut up. Oh God, they are. I said how? Somebody said they've been in Memphis since 2003. Okay. Mm-mm-mm-mm. Let's see. Oh Lord. I'm thinking, do I want to end this live and come back when they come back, y'all? This is weird. I don't want you two to be tripping by how long this live is, because baby, this is long. This is a long, long live, honey. What are we? Oh, 4 hours. We'll sit a little bit longer. Yeah, that's what I was looking at trying to do, like break it up into two videos. So I didn't think they were going to be gone this long. I think I'm gonna go ahead and set up my second video and then just come back when they get ready to announce the verdict. Cause I can always edit it out to take all that dead space out, but Jesus Christ, that's like, I didn't know it was gonna be that long. I thought they were gonna go and be right back. But child, this is like 4 hours. We'll see. I'll wait a little bit longer just to see what happens. We'll wait just a little bit longer. Says more people are waiting, other content creators are waiting too. Well, I guess we'll wait too. I can always edit it. I ain't worried about it. I can take all that out, all that, and merge it back to where it's just like no, no space from right when they went to break to right to where they have the verdict. I'll take all that stuff out, so it's all right. It's all right. Now they're gonna be probably waiting 3 days on Diddy's trial with all that stuff they got on him. Jesus, they're gonna be waiting 3 days on him to come back with his damn verdict. Child, they must have went to Golden Corral for that damn lunch. Jesus. Okay. Yeah, girl, Golden Corral, child, they eating everything at the buffet. That's why it's taking so damn long. Yo, they're stress eating at the buffet. They got our asses sitting on here waiting for 3 hours on them. Yep, you're right, TKO 2890. You're right. That's exactly where they came from. back in Holloway for the Diddy trial. Oh, low down bastard. Okay. And all Diddy's dirt is gonna fall in the courthouse. Yeah. A whole lot of other people's dirt too. Not just Diddy's. Yeah, that's gonna be a good trial. Some stuff we probably don't even know about is gonna be talked about. That's gonna be crazy. Can't wait.
With the AAA Discounts extension, you can find deals on all of life's necessities from over 1,000 of your favorite brands. In life's cherished moments, AAA shares discounts just for you. Available through Chrome, Firefox, Edge, Safari.
Okay, so I'm watching on my phone, guys. I'm gonna just show like some videos in the meantime while we're waiting, okay? Just so you guys don't get too bored. Just some clips that I pulled up from this case so you guys can be familiar with what's going on. I'm gonna pop right back. We're gonna show this right quick.
It's day 2 in the young Dolph murder trial, which much of today's testimony showing video surveillance, prosecutors say, ties suspect Justin Johnson to the car used in the murder. Thanks for joining us. I'm Alex Coleman. April is on assignment. Johnson is on trial for the murder of the Memphis rapper. He's accused of being one of the gunmen along with Cornelius Smith. But prosecutors allege the overall mastermind was Big Jook, a high-up at CMG, that's a rival record label of young Dolph. Big Jook was killed earlier this year outside of a Memphis nightclub. WREG Shay Arthur has been following this case. She's live at the Criminal Justice Center with the latest from today. Shay, what's going on?
Hey, Alex, well, just as I was stepping out to come talk to you, Jamarcus Johnson, that's actually Justin Johnson's brother. He was taking the stand. He has been accused of accessory after the fact, helping his brother. He did take a plea deal earlier this year. He's been out on bond, but today when he's testifying in court, he is not showing his face. Really, he just took the stand about 10 minutes or so ago. And as he was up there, we could see Justin Johnson, who's accused of murder. You could see his face. He appeared a bit emotional at times. So more on his testimony in just a short time. But again, as you mentioned here, much of today's testimony really went back to how crucial video evidence has been in this case. It really goes back to what the prosecutor, Paul Hagerman, said in his opening statement yesterday. He told the jury the problem with these guys getting away with this shooting is that this didn't happen in 1981. It didn't happen in 1991 or 2001. It happened in 2021. There's cameras everywhere, and everyone has cell phones.
On the stand Tuesday, Terrence Dabney, a now retired Memphis police homicide investigator. He handled the young Dolph case. He detailed the crime scene outside of Makita's Cookies. The spent shell casings, videos, and pictures shown to the jury showed 2 men with guns. One of them wearing the Bass Pro hat and the gray sweatpants, prosecutors say is Justin Johnson. The getaway car seen on video, a stolen white Mercedes. Now, rewind back the day before young Dolph's murder, 17 hours before. The jury is shown surveillance video from Crosstown Concourse, where Johnson was living with a relative. You can see a white Ford Expedition pull into the parking garage. Then you see a man on the elevator wearing a Bass Pro hat, gray sweatpants. Prosecutors say that's Johnson. A series of videos spanning several hours, counting down to Dolph's death, is shown, showing Johnson coming and going from the building in the same outfit. At one point, he returns to Crosstown Concourse in a white Mercedes car. Prosecutors also show video of a car exchange at a gas station in the middle of the night where that Mercedes is picked up. Then, around 30 minutes before the murder, video shows Johnson leaving the apartment once again. And once again, he's in the same outfit. This time, he's on the phone with his young daughter. You see him leave in the white Mercedes. The shooting outside of Makita's, the incident captured on video. Young Dolph is killed. Today, the investigator testified those guns used in the murder, an assault rifle and a handgun, have never been recovered. Then, 37 minutes after the shooting, prosecutors say surveillance video shows the accused shooters going to another apartment complex, changing clothes, Johnson into a yellow hoodie, and leaves in a white Expedition. Then, hours later, more surveillance video shows him return to Crosstown Concourse in a yellow sweatshirt, go into an apartment, come back out with his bags packed. Then investigators say he went on the run, starting a manhunt.
They're watching him.
And Johnson was later caught in the Indianapolis area. But again, Alex, as I mentioned, currently on the stand right now is Justin Johnson's brother, Jamarcus Johnson. He has taken a plea deal for accessory after the fact. Prosecutors say he did help his brother with some evidence there they say was involved in Dolph's murder. We'll have more from him tonight at 5 o'clock. For your news leader, we're live downtown tonight. Shay Arthur, WREG, News Channel 3.
If you've been waiting to apply for disability benefits, don't. Hi, I'm Sarah, and I'm a lawyer at Atticus. Applying as soon.
I'll see how they caught him. Yep. That's crazy. That's crazy how they got all the surveillance of them going from one place to the next. Okay, let's share that one. We're just gonna share a few videos of just young Dolph from that day. I'm still watching to see when they're coming for the verdict, guys. Okay. Let's see. All right, so.
Had you ever been there with him?
No, sir.
That's his car.
Had you ever even tried the cookies there?
No, sir.
Did he ever talk to you about the cookies?
Yes, sir.
That's him right there with the yellow shirt on. I remember because he was at that gas station. That's Dolph right there.
The chain around his neck, is that the PRE chain?
Yes, sir.
The one that we saw in the exhibit?
Yes, sir.
Mm-hmm.
That's Marcus behind him?
Yes, sir.
Have this quick.
Yes, sir.
Aspen Dental offers complete care in one place. Dentists, specialists, and labs. How's that for a cleanup?
All right. So that was him in the store, in the cookie shop. That's so sad. Hmm. Wonder why they had to have a GoFundMe. All right, let's play that video. That's a good one. We're just gonna share a few videos.
Makita's Cookies.
A lot of us love it. Well, it happened at the location on Airways Boulevard, and a massive scene out there as family, friends, and fans all gathered to pay tribute to the artist.
The Memphis police chief calling this a senseless act of violence.
Our Jalen Socek is joining us live from outside of Makita's Cookies on Airways, where Dolph was shot. Jalen, what can you tell us this morning?
Yeah, well, you didn't have to know young Dolph's mixtapes, his albums, his catalog to understand what he meant to fans and what he meant to his community. This was a spot that he loved as well. He was just here showing his love for it. Again, unfortunately, it's also where he was shot and killed yesterday afternoon. I'll kind of give you just a little bit closer look here at the scene. All of the windows outside of the store have been boarded up. They had been shot through yesterday, shortly after that. Now, young Dolph, again, was no stranger to this location. Again, was just here about a week ago, seen in one of the last videos he posted, sharing his love for Makita's. Police really have not shared many details in terms of what actually happened leading up to those moments. We know that young Dolph was parked out front and he had walked inside when someone pulled up, and that's when the shooting had started. They have not released any suspect information at this point. Yesterday on the scene, we want to play you some sound from that. It was one of young Dolph's youngest fans. Really shows how much he meant to people.
That was a rapper. That was the first rapper I ever listened to. And y'all just straight up killed him.
Oh, that's so sad.
So that just shows what young Dolph meant to his fans. And there are many of them out there that are grieving, many people here in the community, because in addition to what he was known for musically, he's also known for giving back again here in the South Memphis community. He was back in town for his annual Thanksgiving turkey giveaway. Throughout the show, we're going to be sharing a lot more about how he and his family have given back to this area.
ABC 24's Jalen Socek live for us outside Makita's Cookies on Airways. Jalen, thank you.
That's so sad. The little boy was crying. Yeah, that's so sad. Okay, we're still waiting. They're not back yet. Not back yet. I'm just showing some videos that I found. So sad. That's his car. I remember this video. Let's share this video right quick. It's still not back. All right. Let's see, y'all. Okay. Let's play that. That's
There you go. It's the medical examiner that's being escorted. It's a medical examiner. And the car. And the car. Get the car. The car.
Wow, I remember that car. I remember that car. Wow. What y'all think about that? Yeah. Still waiting on them to come back. Still waiting on them. All right, so we'll play this part. This is another video from the trial. I don't think we saw where he is looking all, this Justin Johnson dude looking all crazy.
Charge and plea. The first count of the indictment charges the offense of conspiracy to commit first-degree murder. Embraced and included within the offense are the lesser included offenses: facilitation to wit, conspiracy to commit first-degree murder. The second count of the indictment charges the offense of first-degree murder. Embraced and included within the offense are the lesser included offenses of second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. The third count of the indictment charges the offense convicted felon in possession of a firearm. The court will now explain to you the law applicable to count 1 in this indictment. Conspiracy to commit first-degree murder. Any person who conspires to commit an offense is guilty of a crime. For you to find the defendant guilty of conspiracy to commit first-degree murder, the state must have proven beyond a reasonable doubt the existence of the following essential elements. that the defendant entered into an agreement with one or more people to commit the offense of first-degree murder. It is not necessary that the object of the agreement be attained, and that each of the parties to the conspiracy had the intent to commit the offense of first-degree murder, and that each party acting for the purpose of promoting or facilitating the commission of the offense of first-degree murder agreed that one or more of them would engage in conduct which constitutes the offense of first-degree murder, and that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step toward the execution of this conspiracy. Intent means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. Conspiracy is a continuing course of conduct which terminates when the objectives of the conspiracy are completed or the agreement that they be completed is abandoned by the person and by those with whom the person conspires. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when the person advises those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. However, mere presence is not sufficient to support the facilitation, to wit, conspiracy to commit first-degree murder. Any person who commits the offense of facilitation, to wit, conspiracy to commit first-degree murder, is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the conspiracy, and that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on page 4. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances, or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable in count 2 in this indictment. First-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted knowingly. Knowingly means a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Facilitation to wit, first-degree murder. Any person who commits the offense of facilitation to wit, first-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of.
Your team comes to work, gets started, and disappears into 100 apps, each with their own greedy little text box.
That the defendant knew that another person intended to commit the specific offense of first-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense.
Okay, I'm gonna pause that because I want to see this right quick.
All right, can you tell me your name, please?
Jamarcus Johnson.
All right, I'm gonna have you look out toward me and speak up so I can hear you, okay?
Jamarcus Johnson.
And can you spell the first and last name for the record?
JERCUS.
And then Johnson.
JOHNSON.
We just have to do that for the court reporter. It's a legal thing. Now, Mr. Johnson, you are actually charged in this case, is that correct?
Yes, sir.
You are charged with taking possession of some of your brother's property after the Dolph killing, and for aiding him to communicate with another man by the name of Cornelius Smith after the Dolph killing. Okay? You have an attorney for that case, is that correct?
Yes, sir.
And he's actually in the courtroom today.
Yes, sir.
You have pled guilty to being an accessory after the fact, several counts of that offense for taking control over a car your brother was driving afterwards, for taking control over a phone that your brother had afterwards, and for helping him by using the phone communicate with Cornelius Smith. Is that right? And you've entered a guilty plea to those offenses, but you have not been sentenced yet. Is that correct?
Yes, sir.
Meaning that a judge has not had a hearing and told you what your sentence is going to be. Is that correct?
Yes, sir.
Have I told you that it's a very good idea for you to tell the truth, and that the truth could help you at whatever sentencing you have one day?
Yes, sir.
Now, this building and this system is new to you, isn't it? Had you ever?
I need you to say yes or no.
Yes, ma'am.
She's recording.
Okay.
Thank you.
Had you ever been arrested before this case?
No, sir.
Ever been to 201 public or court cases and stuff like this before this case? This was the first time?
Yes, sir.
And it's the only time?
Yes, sir.
I want to ask you about your brother, Justin Johnson, okay? Do you see him in the courtroom?
Yes, sir.
Can you point him out and tell me what he's wearing?
Wearing a gray suit.
Okay, is he seated here behind these two attorneys? Could the record reflect he's identified as brother Justin Johnson?
Record so reflects he's identified the defendant in court today.
Now, how old are you, Jamarcus? And how old is your brother? 25? Okay. Is he your full brother?
We got the same dad.
Okay. Same dad, different mother, so half brother or whatever. As y'all grew up, did y'all actually grow up together in the same house every day?
No, sir.
You described sort of how often you would see your brother Justin. I liken it to something like me and my cousins or something. Does that sound about right?
Yes, sir.
So you grew up in a different household than your brother.
Yes, sir.
Is that correct?
Yes, sir.
But you would see your brother from time to time? Is that,
Yes, sir.
would you see him at family stuff? Or
Younger, yeah.
when you were younger? Okay. Like cousins or something? Okay. I want to take you back to 2021, okay? November of 2021. Now, did you even know who Dolph was?
A rapper, yeah.
A rapper, okay. So you knew Dolph was a rapper, okay? Did you have anything to do with some sort of plan on the front end to kill Dolph?
No, sir.
Is that anything that you would ever be involved in?
No, sir.
Any sort of plan to kill other PRE, even though that you know what PRE is?
Yes, sir.
Okay. Any plan to kill the other PRE artists or anything like that?
No, sir.
Okay. In 2021, about how often would you talk or communicate with your brother Justin?
Like every other week.
Like every other week?
Yes, sir.
In 2021, about how many times do you think you saw him that whole year?
Like 2 or 3 times.
Okay. So in all of 2021, you would have seen him 2 or 3 times.
Yes, sir.
Does that sound about right? And you would have talked to him maybe once a week or every 2 weeks. Is that correct?
Yes, sir.
All right. And again, just because the court reporter, like when you nod your head, I know I know it, but we got the court reporter, okay? All right. So it'd be fair to say that y'all were not close.
Yeah. Nah, we were close, but we really didn't talk all the time.
Okay.
Yeah, there's stuff going on. I got my stuff.
Okay. Were his friends your friends? Okay. So did you know the people he hung out with? Did you know, for instance, Treon Ingram?
No, sir.
That name mean anything at all to you?
No, sir.
Okay. Where were you living in 2021?
I was 21
When this happened?
when the murder happened.
When this time period that we're talking about, when Dolph got murdered, and when we're here later that Justin gives you this time?
Oh, the Auburn apartment.
The Harbor Store. Now, what area of Memphis?
East Memphis.
So you were living in East Memphis.
Yes, sir.
Okay. And for people that are not from here, there's downtown.
Yes, sir.
Is that correct? There's Midtown that is next to downtown that includes crosstown.
Yes, sir.
Okay. There's South Memphis, there's North Memphis,
Yes, sir.
and then there's East Memphis.
Yes, sir.
And you were living out in East Memphis. Who are you living with?
I live with my mom and 2 sisters.
Okay. And did you have a son, is that correct? And you have custody of your son. How old's your son now?
Wow.
And were you working back in 2021? Where were you working?
I was working at Disney warehouse.
Okay, at the Disney warehouse. All right. Trying to support your son
Yes, sir.
and living in those apartments with your mom and your sisters.
Yes, sir.
Did there come a time after Dolph was killed that your brother Justin got in contact with you?
Yes, sir.
What was it about?
About bringing me a rental car.
About bringing you a rental car. Now, had you asked him for a car or anything?
No.
Okay, so this is, do you know what out of the blue means? Would this be something sort of out of the blue?
No, he knew I didn't have a car.
Okay, your brother would have known you didn't have a car.
Yeah, he knew I didn't have a car.
And was not having a car hard for you?
Yes, sir.
Who had to drive you to the warehouse?
I had to get rides.
You had to get rides. Okay. So your brother, is this after Dolph was killed?
Yes, sir.
Okay. Calls you about giving you a car.
Yes, sir.
Does this sound good to you?
Yes, sir.
All right. What happens after the phone call?
I was getting out from work on the way home, and he was like, he's gonna call and bring me the car so I can get back and forth from work. You know, I can get the car. So.
Okay. And did he in fact do that?
Yes, sir.
Where did he?
Like an hour later to the office.
Like an hour later? At your apartment complex? Okay. What kind of car did he arrive in?
It was a white Chrysler.
Okay. You know what a Chrysler 200 or 300 looks like?
I think it was a 300.
Okay. Oh, they look similar, 200, 300, right? Yeah, I was just asking, does it look like one of those things?
Yes, sir.
Okay. Is he driving that car?
Yes, sir.
Does he have anybody with him?
There was some people in the truck.
What kind of truck is it?
I really don't know.
What color is the truck?
It's white.
A white truck? You say truck, you mean like a pickup truck, or do you mean like a big SUV? Big SUV? Okay. Do you know who the people were in the white SUV with him were?
No, sir.
Okay, what happens when he gets there?
Tell me you outside.
Okay.
Go outside, get in the car.
You get in the car with him? All right.
Quiet. He had 2 phones.
Okay.
Okay, so I guess he was putting numbers in the phone and stuff.
He was in what?
He was like switching the numbers, putting numbers in the phone, another phone.
Okay, so he has 2 phones in front of you, and it looks like he's taking numbers from one and putting it in the other?
Yeah.
Okay, now had y'all talked about a phone or anything before? All right, he was bringing you a car. You're in the car. He's got 2 phones. Before this conversation about bringing you a car and stuff, when was the last time you had talked to him?
Probably like 2 or 3 weeks before bed.
Okay. All right, so you meet him in the car, he's got the 2 phones, and he's going back and forth with the numbers. Were you asking him what he's doing, or what's going on?
He was just quiet.
Okay. And what are you doing?
I was on my phone.
Okay. So you're sitting there next to him, you're on your phone, and he's doing his number stuff. What happens?
He tell me he was gonna give me the phone. It was like social media stuff.
Like that he's going to give you one of his 2 phones. Okay. And you said for social media stuff?
Yeah, post some pictures and check me emails and stuff like that.
Does your brother have social media?
Yeah, Instagram, yeah.
Okay. In fact, you know your brother, does he go by other names too?
Other than his real name, Straight Drop.
Okay. Straight Drop and sometimes just Drop.
Yeah, this is real.
Okay. And when you say give it to you for his social media, what do you mean by that?
Kind of like I don't know, I guess he was just busy. He just needed me to keep up with like the people that was emailing like
Okay, so,
stuff like that.
all right, so let me back up. He gives you his phone. Because it's the idea that people may be calling or texting or messaging him.
You can say that, but it was just mainly he just told me that he needed me like to post some stuff.
Okay, so he told you at the time that he needed you to use his phone to maybe post some stuff to his social media. Is that
like videos, all this stuff?
okay? Did you ask him why he couldn't do this himself with his phone?
No.
Okay, but he has this phone in his hand. He's going to give it to you, and you already have a phone. You don't need a phone.
No.
The car sounds good. And he wants you to have his phone and maybe post stuff to social media.
Yes, sir.
Okay. You don't ask him why. Does he provide any explanation?
Other than just for the social media stuff.
Okay. He doesn't say why he needs you to do this rather than him. Does he tell you that he's getting out of town?
No, sir.
Does he tell you that he's got to lay low?
No, sir.
What happens after he gives you the phone?
Somebody was calling him, like rushing him to come on.
In the car there? So he's getting a phone call from while he's in there?
Yeah.
On one phone or the other, you know?
I don't know which one.
Okay. And so does that end y'all's little meeting?
Nah.
Okay. What happens?
Still sitting in the car.
Okay.
Yeah, he was still doing the same thing.
So putting numbers back and forth?
I mean, he just had both the phone. I wasn't looking to see what he was doing. That's what it looked like he was doing.
Okay.
Looking at both phones.
Once got done putting numbers or whatever he was doing with both phones at the same time, what happened?
Nah, I asked him, was he straight? He said, yeah. Then they called again. Whoever it was called him again. Anybody here come, so he got out the car. He had the key. I went in the house.
Okay, so he gets out of the car. Did he get in that white SUV with other people?
Yeah.
Okay, and you go into the house. And now you have a car that he's getting in. All right.
Yes, sir. And
you have a telephone that was his.
Yes, sir.
After you get possession of this phone, do people start trying to contact him on this phone?
Yes, sir.
All right, but you have the phone.
Yes, sir.
What happens when somebody contacts him on the phone that you have?
I text him and tell them that they called or text.
Okay, so if somebody calls him or texts him and you then text him or call him and say so-and-so just texted or called you, is that right?
Yes, sir.
Were there ever times that somebody would call that phone and then you and your phone would call another phone and put them together so that they could talk?
Yes, sir.
Okay, so you could aid in those sort of, sometimes we call it three-way or whatever, conversations between him and other people?
Yes, sir.
Okay. Among those sort of three-way conversations, did he ever talk to somebody identified as C?
The name in the phone was C Girl.
Okay. And the voice, was it a male or a woman?
The one time that I did really do sound like
Sound like a G. At the time, did you know who C was?
no, sir.
Do you now know that to be Cornelius?
Yes, sir.
Were you able to hear a conversation going on between Justin on one end of the line and Cornelius, since you are sort of three-way there?
Not like full conversation.
Not the full conversation. Were you able to hear some of the conversation?
Just a little bit. I wasn't really just listening.
Okay. You've been asked before whether or not you heard some of the conversation, correct? And have you described part of the conversation having to do with money?
Yes, sir.
Having to do with getting money to C?
The text message.
The text messages? And what was it about?
It was like, he just kept saying like, "What's up, bro? What's up, bro?" What's up, bro? And stuff like that. And I was texting my brother, and I was telling him somebody texted me, and he was like, who he is and what he wants. And then when I told him, he kept saying like he loved him and stuff like that. And then he said, have you talked to Uncle?
Okay. Did you know who Uncle was at that time?
No, sir. He said, talk to him. Then he said, if you talk to him, tell him I need some money for my little girl's birthday party.
Okay.
Yeah.
And did that make any sense to you?
I really make that.
About money, though.
Mm-hmm.
The money that would be coming from Justin and Unc to this C person.
I don't think it was coming from Justin. I think it was just coming from Unc.
Coming from Unc.
To ask Unc.
Okay. So C was asking Justin to ask Unc where the money is. At the time, did you know who Unc was? At the time, had you ever even heard of Big Joke?
I knew he was. Yeah.
Had you ever met him? Ever talked to him? Okay, but you knew his name?
Yeah.
From the rap game and everything else?
Mm-hmm.
Did you use that phone like that? I mean, would various people text and call, and you tell your brother, hey, so-and-so text and call?
It was only it was a couple people. Yeah.
Couple people? Okay. During the course of doing this, did your brother ever tell you where he was?
Talking about after he left from
He never told you where he was? Okay. At some point, the police come to you, is that right?
Yes, sir.
They come to your apartment?
Yes, sir.
And they want something you got. Is that right?
Yes, sir.
They want that phone.
Yes, sir.
Your brother's phone.
Yes, sir.
And did you give them that phone?
Yes, sir.
And did you agree with to go back to the station with them and, be interviewed by the police? Did you do that?
They took me there.
They took you there, okay. Yeah. They took you there. You turned over the phone and told them about Justin giving it to you.
Yes, sir.
Now, the original reason that he gave you for his phone was so you could do postings on social media and stuff.
Yes, sir.
Did you do postings on social media for him while he was gone? Which two pictures?
It was like a picture of some food, like in a restaurant.
Okay.
And another one was like some shoes.
Okay. So you posted two pictures for him. Which would be a picture of some fancy shoes?
Just some Jordans.
Some Jordans. And a picture of some food. And did he ask you to post those pictures? Okay. Did you also follow his social media? Did you see the stuff he posted on social media?
Yes, sir.
Was he still posting stuff on his social media? Not just you?
Like,
Like a picture of him in a Rolls Royce, or a picture of him holding tens and tens of thousands of dollars?
like, not like around the time I posted those pictures.
I understand.
Further on down the line.
Further on down the line. Okay. Before he got arrested.
Yes, sir.
So that's not you posting those pictures. In fact, I think you had already, they had probably already had, the police already had the phone about this. Pass you exhibit 57 and 56. Tell me who's in this picture, if you would. I think you sent me those before, Marcus, is that right?
Yeah.
Who's in those pictures?
Justin.
Your brother, Justin? Okay, have those exhibits returned? I'm trying to ask you questions, Marcus.
One moment. Good afternoon, Marcus. If you don't mind, I'll call you Marcus since we have more than one Mr. Johnson in the request. Sir. All right. My name's Luke Evans. I just got maybe just one question for you, or a couple of questions for you. So you knew Justin to be an aspiring rapper.
Yes, sir.
Correct. He was trying to get signed.
Yes, sir.
Okay. Had you ever, prior to that date, ran his social media or YouTube before?
Yes, sir.
All right, so that wasn't a new thing for him to ask you to do.
No, sir.
Okay. All right. Thank you very much.
Nothing further, Judge.
Thank you, Mr. Johnson.
That's it.
Yes, sir. Step back.
So y'all see that? That's where we're still waiting on them to come back, guys. They're not back yet. Let me see, can I find some more of this? That's in conjunction to this case. Because child, it's a lot. Okay, we don't want to hear you, ma'am. Okay, hold on. Hold on. I can't believe these people still ain't back, y'all. It's weird. Okay. Oh no, that's the Breakfast Club. We're not gonna play that. Okay, hold on. Okay. Killed by investigator. All right, we'll watch a little bit of that one. But this looks interesting too. I don't know how I missed so much of this, and I've been trying to keep up with this case. All right, we'll watch this. This is the young Dolph unaliving evidence revealed by the investigator. So let's look at the evidence that they have. Okay.
Some of the various crime scenes with you, some of the various aspects of the investigation. So try to get as comfortable as you can, even with your arm. But I know you're doing good now too, because you're retired, is that right?
That is correct.
Retired from MPD?
That is correct.
How long were you with MPD?
26 years.
So 26 years, let's say you earned it. In 2021, where were you assigned in MPD?
I was assigned to the homicide.
All right, and what did you do in homicide back in 2021?
I was an investigator.
In homicide here in Memphis, do you get a case and you're the only person that works on the case?
No.
Do y'all work in teams?
We work in teams.
And were you one of the case officers on this case?
I was.
Would you assign and delegate people to do various things in the investigation?
I do. Delegate people.
You're actually from Memphis, aren't you?
I am.
What neighborhoods did you grow up in?
I grew up in Claiborne Homes, Castaic.
And Claiborne Homes is downtown Memphis.
Correct.
And in the Castelia neighborhood. And we've heard some testimony about the Castelia neighborhood. Did you know Dolph at all?
No.
Older, is that right?
Older, much older.
All right. November the 17th of 2021, did you have occasion to be brought in with regard to a homicide call?
I was.
Specifically to an address on Airways, Makita's Cookies.
Great.
Did you know where that was?
Yes.
What area of town is that?
It's in the southeast part of town, Airways, Ketchum area.
If I tell you that the call went out at 12:24 p.m. in the afternoon, about what time would you have arrived at the scene?
Possibly around 1. By the time you get the call, travel to the scene.
By the time you get to the scene, are there uniformed patrol that's already there?
Yes.
Are there medical personnel and things like that already there? When you get there, what are your duties?
My duty is to gather fact information from the reporting officers, delegate other investigators to do, canvass the area for video, and just handle process the scene.
When you arrived on the scene, were there people around in the street and everything?
Yes, there were people
Everywhere?
around.
Were there officers attempting to control the crowd and keep people off the actual parking lot of Makita's?
Yes, it was.
And was that being done?
Yes, it was.
Were there a lot of bystanders and everything looking on and everything else?
It was.
Does this seem almost like any other that you had been to in your 26 years?
That scene was, it's a lot of people.
Okay. You get there, and you say your job is to try to figure out what evidence exists and delegate.
Yes.
Is that right? You mentioned one thing, video. Is that right?
Video.
Are y'all interested in collecting any video that may be around that?
Any video that would help in the investigation.
And in fact, did y'all collect video from the cookie store itself? And did it show the outside of the business?
It did.
And did it show the inside of the business?
As well as the inside.
You need your team, but she's lost in emails. He's consumed by a doc. You lose them for hours every day. But
We're back. We're still waiting
Were
on the
y'all
other.
also interested in sort of crime scene stuff?
Yes.
Did you delegate a crime scene detective to collect physical evidence and document physical evidence?
We did. We had collecting and processing.
And did they also take pictures of the scene?
They did.
Would you have delegated or interacted with any of the witnesses who were on the scene?
Yes. Witness victims. We have investigators to take them down to headquarters, take statements.
Okay. And without getting into what these people, said, did y'all talk to Marcus Thornton, Dolph's brother?
We did.
Did y'all talk to the cashiers there at Michaela's?
We did.
Did y'all locate any other witnesses right there in the surrounding scene that had information?
No.
Video, crime scene, locate whatever witnesses we have. That address on Airways is Makeda Cookies. You described the area of Memphis is in. That's in Memphis, correct? And is that also in Shelby County?
It is.
I'm going to start with the crime scene there. I'm going to pass you a series of photographs. You just look at them, tell me what's pictured in each one, and place it face down on that table next to you.
This photo is a front picture of Makeda's cookie shop. Officers there processing the scene, broken glass. They have victim's car.
Very good.
Corvette, camouflage color.
Okay, you can place that face down. We're going to review these with the jury afterwards, so I'll ask you questions about them afterwards.
This one is the photo of the address, 2370 of Makeda's cookie shop with defects to the glass, bullet holes.
Okay.
This one is the inside front counter area of Makeda's cookie shop.
Okay.
This one is another front view of the cookie shop, Makeda's cookie shop. We have evidence markers on the ground where we have shell casings, along with the victim's Corvette camouflage. Another closer picture of the front of the cookie shop, evidence markers, broken glass, casings.
At this time, you can just place it, so that's fine. With the next couple pictures, you can just place it where you see it, and we'll show it to the jury later.
Okay. This is a picture farther back from Makeda's cookie shop toward the street airways with evidence markers with casings on it. This photo is inside the business of Makeda's with bullet holes going through the walls and doors. This one is a victim lying on the ground.
And when you arrived on the scene, was the victim still there?
Yes, he was.
Did you observe him positioned like that?
Yes, sir.
Do you see evidence of medical intervention on him there?
Yes, he has bleeds on his body.
When you arrived, were they still trying to resuscitate him or get anything, or was that process over?
The process was already. This photo is a photo inside the cookie shop. We have evidence markers. We have victim's chain that he was wearing inside a flower pot. PRE on it. This is a close-up photo of PRE charm that he had on his neck. It's just inside a flower pot.
All right. My approach real quick, Judge. For the record, the last picture he looked at has already been marked as text exhibit number 3.
All right, this first photo is has been described as the front of the Makeda's cookies with the victim's car. A couple of officers in the scene will mark this as exhibit number 28. Next photo is close-up of the address of Makita's Cookies, 2370. We'll mark this as Exhibit 29. The next photo is what's been described as the inside front area of Makita's Cookies. Exhibit number 30. Mr. Evans, it's never too late. Any objection to these photos?
Yes, Your Honor, no objection.
The next photo is the
Hey, I'm Stephen Karst, co-founder of King of Pops. When I open the Zero dashboard, I can quickly see how my bank balances are doing, what money is owed, and what bills are going out, and that gives me a lot of confidence to make informed decisions.
Your gunk is gorgeous.
front view in of the parking lot in the front of Makita's Cookies with the evidence markers in the victim's car. The markers number 31.
Judge, and you haven't gotten to the photograph yet, but the one we referenced earlier is in that stack. I would renew my objection.
Yes, sir. When I get to it, I'll make note of that. The next photo has been described as a closer picture of the front of Makita's Cookies with several evidence markers in glass and defects to the window. We'll mark it as exhibit number 32. The next picture is the front of the shop with the victim's car and evidence markers. It's a further view. It's a picture that's taken a little further out. We'll mark this as exhibit number 33. The next picture is the inside of the building with the picture of the restroom door with the bullet holes in the door. We'll mark this as exhibit number 34. The next picture is a picture of the victim lying on the ground with markers of evidence of life-saving measures in front of the window. We'll mark this as exhibit number 35, and note for the record, there's been a previous motion for the court to exclude that picture under Rule 403, and the defendant still objects to that court matter. Mark that as exhibit number 35. Exhibit number 36 will be a picture of the inside of the cookie shop with the chain on the floor marked with evidence marker number 53 and several other evidence markers. Exhibit number 36. The next picture is exhibit number 3, has already been marked as exhibit number 3. The picture of the charm, PRE, in the flower pot.
My question, have this, Your Honor.
You may.
Mr. Gabby, we're gonna show these to the jury and ask you some questions as we go, okay?
Yes.
You need a pointer?
Supposedly, this one right here was. We'll see.
Yes, sir. Yes, sir.
look. This picture's so blurry on the overhead. Maybe we resume the lights. We're gonna have to go sort of old school.
All right.
On this one, could I have the witness step down? Hold this here. We'll start standing here, and I'm gonna ask you some questions about it, and then you can walk down and display it to everybody. After you testify, maybe we'll pass them as a statement over to the jury. Okay? Oh, you just hard for you to hold up, didn't it? But then, or am I? I'll just square it down. Tell me what we're looking at in this photograph here.
This is the front of Makita's cookie shop here. You see the name there. You see officers in now processing the scene. And that's Adolph Gordon's Corvette. The camouflage color.
Okay. And if I'm interested in this area here in front of the store, in front of this glass window.
Those were bullet casings in glass, broken glass.
Okay. And in particular, what kind of shell casings are found outside that window where we see the officers bending down?
On the outside, we had 40 caliber shell casings, and we also had 7.62.
Okay. And let me ask you about that. Is that two entirely different calibers?
Yes.
Two entirely different sizes?
Yes.
Two talented football teams on both sides of the ball.
It's 40 caliber characteristics of a handgun.
Characteristics of a handgun, it is.
And then is a 7.62, is that characteristics of something else?
Of a assault rifle.
Assault rifle. Okay. And have you watched the video obtained from McKinnon's?
I did.
Is it clear that one suspect is firing at what you would call an assault rifle?
It is.
And is it clear that the other one's firing what you characterize as a handgun?
Mr. Harriman, it never fails that something goes wrong with our tech. Is that your tech person that just came in?
She is.
Can you
We'll see how we do
help
here.
you?
I would prefer that we just
Yes.
see.
So we can all see what's going on, because I was gonna have to get over there, and Mr. Evans was gonna have to get over there, so.
I'm trying to turn it off and on back. The next one is to kick it, but we're not gonna do that.
Technology is good, but we get used to it until it doesn't work.
Yeah.
Oh, that's good.
Well, that's real good. That's real good.
So don't you do, turn it off.
The on and off thing worked. This is that picture we're just looking at, right?
You have to see.
That's much better.
Don't go far.
I was asking about this area right here, is that correct?
Correct.
And you said that we found two types of casings in that area?
Two different types. We had 40 caliber casings, and we also had 7.62.
Okay, and 40 caliber is a handgun case, and 7.62 is that assault rifle casing?
It is.
And this is the victim's car, is that right?
It is.
And this is where we walk in and out of the business?
The entrance.
And this is a little side area?
It is.
And later we're going to see the victim lying in this little side area, is that right?
That's correct.
The front of the store?
In front of the store with the address 2370 of Makita's Cookie Shop. We also have defects in the glass bullet holes in the glass of the door.
And we'll see this with a later picture, but let me go ahead and ask you about it. Do we find casings from inside the store where Dolph's brother was firing back from?
We did found 9mm.
Okay, and that's an entirely different type of handgun too, is that correct? So we have 9mm casings inside the store.
Inside.
We have 40 caliber casings outside the store, and we have 7.62 casings outside the store. And on a later picture, I'll ask you about one more set of them. Counter area of the store.
Front counter area inside of the business.
For perspective, the cashier's booth or whatever, would the register would be right around here, is that right?
It is.
Mr. Hagerman, if you can tell us what exhibit number that you're using, please.
Going in order, this is 30. 31. That same outside area, is that right?
Same outside area from a different angle. See the victim's front end of the victim's vehicle, Corvette. And see the glass, some of the glass is broken out of the front windows to the bullet hole.
Glass broken out here.
Yes.
And bullet holes throughout this glass, is that right?
It is.
This is the next number exhibit, 32. Closer in.
It's a closer picture of, like I said, the shattered glass, bullet holes. You have markings on the ground with broken glass, shell casing of the 40 caliber, 7.62 round.
And later on, when we see the victim's body, is it going to be in this area here?
It is, right in that area.
And when we see flower pot, like with his necklace and things like that, over this area?
Further to the left building, yes. This view is view that's farther back from the entrance of the business of Makitas. On that ground there, it's closer to the street of Airways. On the ground, you have evidence markers with shell casings there. And we found 2.26 rounds.
223 maybe?
2.3, I mean.
So if we're gonna, I think now we've accounted for all the casings.
Yes.
So let's start from inside the store. There are 9mm casings from Dolph's brother, is that right?
Inside the business.
There are semi-automatic 7.62 casings from one of the shooters.
Find purpose, build momentum for your studies, career, and life. Comparisons fail. There's only one Barry.
When you grab the disposable ball aluminum cup, you experience a premium cup. You'll feel the cool.
Correct.
There's 40 caliber casings from another of the shooters.
Correct.
And then there are these 2.23 casings, and is that a type of semi-automatic weapon?
Yes, it is.
From Dolph's brother as he runs out.
That's correct.
That's exhibit number.
And that car right there is the man from that's his car, that black car over here. My mouse.
This is 34. What are these things?
That's inside of the business. You have a door, entry door into the bathroom. It leads to the hallway that leads to the bathroom. It has bullet holes and shattered glass on the door.
And perspective from inside the store, the register's over here.
Correct, it is.
We're about to see a picture of the victim's body, and it is going to be in the area of this little side area. Is that right?
Correct.
I'm going to go out of order to exhibit 36. It's just that little side area.
That's the little side area we referred to earlier. We have the flower pot there with its charm off of his necklace. It says PRE. His necklace is down toward the bottom of the photo.
And then
Your mark was 53.
And if we were to come this way down a little bit, would we see the victim's body?
We would.
Close up. Already marked, stays exhibit 3. the PRE, charm or whatever?
Yes.
I'm gonna do this one a little different. Families in the courtroom. Officer Danny, if I may publish this to the jury, just myself here. This is a graphic photo, correct?
Yes.
This is a picture of the victim laying there in that area that you just described.
Yes.
He is still in his clothes.
Yeah.
But there's evidence of medical intervention. But that was over. Obviously, by the time of the picture, but when you were there, he was deceased.
Correct.
This is
Exhibit number.
This is exhibit number 35. Y'all obtained the videos from out there?
We did.
And were you able to view those that day?
We did.
Let me show you a still shot from the video, ask you if you recognize it.
This is a still shot from the video of outside the front entrance of Makita's cookie shop, which shows victim's Corvette. It also shows a white Mercedes that's pulled in behind the victim's Corvette. It's a two-door. On the Mercedes, you can see it has damage on the passenger side rear. You have two suspects. One is armed with a
This is the vampire Louis Dulac.
assault rifle, what appears to be an assault rifle. He's wearing a mask over his face, no cotton mask, like
Still no
wearing a
verdict,
blue
guys.
hoodie,
Still waiting.
with some sweats, gray sweats,
Multiple
shoes.
screens.
And the other suspect, he's wearing a black baseball cap, but it has Bass Pro on it. Also has his face covered. Has a black hoodie, some gray sweats. The gray sweats has a little, I guess, insignia on it. He also has some dark colored shoes with white on it.
All right. Oh, good. That marked the 66 number exhibit, Your Honor.
The witnesses testified that this is a still shot from the video camera outside of Makita's Cookies with two people, one standing still with an assault rifle with hoodie and mask, and another one running with what appears to be a gun in his hand, a smaller gun with two cars, the Corvette and white Mercedes in the back. We'll mark this as exhibit number 37.
No objection.
Thank you.
I could already tell that when I handed it to you, I just said still shot. You look at it like an investigator, telling me details that I guess added to you. Is that right?
Yes.
This is exhibit 37. And y'all had this on day one of the investigation, is that right?
We did.
First thing you mentioned, I think, was one shooter with, is that an assault rifle?
It is.
And would that be consistent with the gun that shoots those 7.62 cases?
Correct.
This window, is that the one you saw busted out with the pictures that we just saw?
It is.
With the victim lying here?
Yes.
And this is that, would this be that side area of the store?
It is.
From that first day y'all would have this image of the suspect with the 7.62. Is that right?
It is.
Hoodie. Does he appear to be wearing gloves?
Wearing gloves.
Sweatpants. White shoes. Mask.
Yes.
Second suspect. Kind of gun here.
Yes.
Handgun.
Handgun.
Handgun consistent with 40 calibers that you would have seen here.
Yes.
We're still operating with some blur, but gray sweatpants, is that correct?
That's correct.
Black shoes, white soles.
Yes.
It's better in the picture than it is on the overhead. You said something about a white insignia, is that
like
correct?
a little insignia designer on sweats on the side there.
It's good. If I put the cursor on it, covers it up. We'll pass this around in a second. Black hoodie.
Black hoodie.
Mask.
Mask.
Gloves.
Gloves.
Bass Pro hat.
Bass Pro hat.
Suspect vehicle.
Yes.
What kind of car is it?
It's a Mercedes-Benz.
Color.
White.
And you see it better in the photo than on the overhead, but what did you say about this back area?
It has damage to the rear passenger side.
And these details we just went through, why are those, were those important to you that first day?
Yes.
And why is that?
So we can, be on the lookout for that type of vehicle with the damage that it has to it.
Okay. Because that made that vehicle distinctive.
Yeah, stand out.
Would it be fair to say that there's no still shot or camera angle which you can actually capture the suspect's entire faces?
No.
So from the first day, you do not have any type of facial identifications or anything of the two shooters.
No, we do not.
But you have clothing descriptions,
Clothing description.
gun descriptions,
Gun.
Okay. And suspect vehicle. I meant to ask this earlier, but it makes sense now. So assault rifle like this can shoot 7.62 casings, is that
Yes.
right? A handgun like that can shoot 40 caliber casings?
It can.
If I've got casings that have been fired, and then I actually recover the guns.
Okay,
Can I
so guys, we're
compare
back.
casings
We're
to
back. All right, let's
guns
pause
and
this
tell
and
you,
get back.
That 40 caliber
Let's
casing
get
came from that
back
40 caliber gun.
Original video. Okay. Y'all see? All right. Boom. Finally. Back. All right, let's see what we come up with. For those of you just joining, this is the verdict for the young Dolph case for Justin Johnson. Okay, somebody said it's frozen. Nah, it shouldn't be. It shouldn't be. Get another screen. Yeah, on their end it is.
Yes.
We see that on TV sort of all the time. Is that right?
Yes.
Is that something you do, or is that something?
Oh wait, no. Hold on. Nah, they're moving. They're moving. Let's make it big. Hold on, guys. I'm sorry. Why are they breaking again? I don't get it. Hold on, guys. Jeez. Oh, live. Okay, they just took like another little recess. I don't know what they're doing. What? Let me back it up a little bit.
To the term agreement.
All right, so this is what they're saying. Back it up just so y'all can see. Go forward a little bit.
Legal definition. I think they're overthinking it.
Yeah, like it's the
common term,
Yeah.
right?
Common term.
I don't know that I can even say all of that to them. I probably could just say no, or
I think you could say no.
Y'all good night.
The only other thing I can think of is you could direct them back to the part of the jury instruction that says, based on your everyday experience.
It's not clean.
You know, that one line, I can't remember where that's.
Y'all see it now?
I think you know what I'm referring to.
Put a one in the chat if y'all see it. Is it playing? We're getting ready to take another little break. Okay, so I see one. Okay.
Court's back in session.
so for the record, the jury had a question. Their question is there a legal definition to the term agreement relating to section 1, page 5? Agreement is in quotation marks. So I don't think there is a legal definition to the term agreement.
So, you know, I remember struck it as answering a question before with a jury saying that when a word doesn't have a legal definition, that's why here to go with the common, usage. But beyond that, I don't think anybody can comment on that.
Right. Or I can say, no, there is no legal definition, which leaves them with their common knowledge about the word.
I would just suggest to say common, like you said, there is no legal definition, and when there's not common meaning of the word, but everybody.
Mr. Evans?
I think based on kind of thinking about it for a minute, I think you can only, I would suggest just saying there's no legal definition. I don't have a problem with saying.
If that's what Mr. Evans is asking for, that's fine.
With saying something to the term of, everyday usage, or what I was referring to is consider all the evidence in light of your own observations and experiences in life, but that's not really specific to defining a term, so that may not be helpful to them, but I think either way it's phrased, it would be fine.
All right, and I'm just gonna respond to this in writing. We don't even have to bring them out, okay? There is not a legal definition for the term agreement. Okay? I think the less the better here.
I agree.
Okay. All right. Thank you. Adjourn court.
Okay, so they're taking, looks like another little break until they come back. Jury, I don't know what the hell they doing back there. But baby, y'all need to come on. So they're back to like another little break. So I'm going to flip back to until they get done rather. We're going to flip back to the other video we were watching, okay? We're going to flip back until they get done. And then we'll resume. I'll be watching from my other device to make sure we are back in time. So y'all don't be sitting idle. Because I know it's boring. Okay. All right, so let's get back to that one.
That's done by other people.
It's done by other people.
Is it first done?
What's she saying? Okay, looks like the judge is back. What are they doing? All right, so let's get back to that. Well, they just well, let me stop sharing and go back to it. This computer is doing the most. My goodness. Okay, let's go back to the live. Okay, the judge was just sitting there. I don't know. Okay, well, don't look like they're back. Look like she was back and then they're not back. That's so weird. All right, so let's flip back. Let's flip back. I don't think they're ready. All right, so we'll
weapons in this case?
No, we did not recover any.
So you never had any guns recovered that matched these shell casings?
That matched those shell casings.
Yeah, the jury, they're not ready. I'll be watching from my other device when they come back out.
All right, we're going to change locales. We're going to change locales here to an address, Haven Court, in what used to be the Tulane Apartments.
Yes.
Okay. How was it that y'all became interested in that location?
We're on the lookout for white expedition.
Okay. At some point in this investigation, without sort of saying what the tip was or anything like that, was y'all's attention called to a white expedition?
It was.
And did that cause y'all to go to what was called the Tulane Apartments?
Yes.
And what did y'all do when y'all got the Tulane Apartments?
We watched video.
Okay, did y'all take video of the Tulane Apartments? Okay, and that's the address on Haven Court. Okay. I think we do need to play the Haven Court. We're going to get that video ready to play for you, Detective Dabney. At the Haven Court Apartments, were y'all interested in a particular woman that lived there?
Yes.
And was that Kiana Hopper?
It was.
And is she related to anybody involved in this case?
Yes, it was discovered that she was related to.
Was it discovered that she was Justin Johnson's cousin?
Yes.
All right, got the video ready now. Haven Court Apartments, 1 p.m., 37 minutes after the murder. For the record, this is Exhibit 5 that's held open for all the video shot. Who is this person, Detective?
That would be the cousin.
The cousin?
Kiana.
I always wanted to have a hobby. I tried lots of things.
What kind of car is that right there?
And that's the white Ford Expedition.
Kiana?
Kiana approaching the Expedition.
Two men outside. Go ahead. Were you interested in those two men?
Yes, I was.
Tell me why you're interested in those two men.
And the clothing that they have on. You see the dark sweatshirt, the gray hoodie. I mean, the black hoodie with gray sweatpants, shoes, matching the description of the suspects that were at Makita's Cookies.
Y'all obtained video not just of them arriving, but while they were there and then leaving, is that correct?
That's correct.
Before they leave, what will be this? They arrived 37 minutes after the murder. This is 54 minutes after the murder.
It is.
The expedition's still there, is that correct?
That's correct.
Suspects are still inside.
Still inside.
This Dodge Charger has just arrived.
Dodge Charger arrived, and we see one of the suspects come out and walk to the Charger. Yeah, you can see.
Charger just sort of repositions, but this man came outside, is that right?
Yes. Came out, walked to the rear of the.
You're interested in this man?
Yes.
Sweatpants?
Sweatpants, black shoes, white soles on. Coming into the car.
Got your ass, buddy.
He's got bags or something
Yes.
now?
You see how his pants are sagging there a little bit. We have that was something that we looked at also.
In the homicide video, as he runs away, we can see his pants are sagging.
Yes.
Can we in fact see the color of his underwear in the homicide video?
Yes.
Is it also blue?
Yes. He gets into it and shuts the door.
like a yellow article of clothing or something now?
Yeah, looks like a yellow hoodie.
Is this apartment building here the one that Kiana Hopper lives in?
Yes, it is.
And then a video of the move. We're now 93 minutes after the murder. Vehicle here's a Chevy.
It's a Chevrolet SUV, small SUV.
Do y'all get interested in that one too?
We did.
Expedition still there. You had a yellow article of clothing when you left that Charger?
Yes. It's waiting on the one that appeared that he got out of the Charger. The suspect gets in, Kiana comes up to the driver's door.
The other suspect has walked off camera, is that right?
He walked out of view to the right of the video there.
Chevy's back.
Correct.
Suspect returns to the apartment complex.
He did.
Suspect returns to the white Expedition.
He did.
The Chevy track still there.
It's still there.
Kiana.
Kiana. lady and the Chevrolet.
All right, the expedition got going and the Chevy Trax got going.
Yes.
One suspect in each, is that right?
Yes.
Y'all obtained the video, interested in talking to Kiana,
Yes.
interested in her cousin, interested in the white expedition, interested in the Chevy Trax, and who this other person may be. We are going to move there's one thing I said I was going to do that I didn't do before. The still shot from the actual shooting from 37. We talked about how it was blurry up there, and there were things you were testifying about, and I couldn't quite get the pointer in the right place. And one of those was the fact you said there was a little insignia or something on the left thigh area of the sweatpants of the shooter who has the Bass Pro hat on. Is that right?
Correct.
If I could pass this around to the jury, Your Honor. It's hard to see on the other end. With regard to the videos that we just watched from the two-lane apartments, did investigators make a timeline with still shots from the various things in that video?
We did.
Let me pass you this. We could just verify this is in fact that timeline from the Haven Court, what we also call the two-lane apartments.
This is said photo of the timeline. First arriving was a white SUV.
Yeah, if you just flip through it quick, does it appear to go from the start to the end?
It does. Start to the end. Another one where Kiana had walked out and walked back to the expedition. It also shows the two suspects getting out of the expedition and walking toward the front of the apartment complex. This one shows them inside the apartment, one inside the apartment. Also shows the charger pulling up. Shows one of the suspects walking out to the Charger and getting to the rear passenger side of the vehicle. Shows suspects retrieving plastic, 2 white bags, then get inside of the rear seat of the Charger. And once he exits the Charger here, getting out with the 2 bags and a yellow hoodie in his hand and walk back toward the apartment complex. This one shows 2 suspects exiting the apartment complex with one with the yellow hoodie, one with the black hoodie, carrying bags, and Kiana is also with them. They walked up to one of the suspects walked and got into the white Expedition. The other got and walked over to the Chevy tracks.
Now we pose that as a collective exhibit. You can paperclip it or something. It's in order, so we could keep it like that.
This is 8 pages of still photos starting on November 17, 2021 at 12:58. Going to November 17, 2021 at 13:56. We'll mark this as a collective exhibit number 38.
All right, we're interested in Kiana's cousin, we're interested in White Expedition, we're interested in Chevy tracks. But is there other stuff going on in the investigation too?
Yes,
Does a tip come in with regard to a white Mercedes?
it did.
And does it call your attention to a particular place?
Yes, it did.
A small street in Orange Mounds?
Yes,
Bradley Street, is that correct?
correct.
1174 Bradley Street. What is at that location?
It's an abandoned home, and when we get there, we've observed a white Mercedes parked in the rear. Had damage to the passenger side rear side panel.
And to put this in a chronology, would this have occurred on November the 20th, 3 days after the homicide?
Correct.
And it would be fair, would it be fair to say that 3 days after the homicide, behind that abandoned house in Bradley, y'all found the murder?
We did.
Okay, guys, they're back. Let's get back. Ah.
Pause and go back to, hold on, wait a minute. What am I watching? Oh, never mind. I got so many damn screens up. I was like, oh my God. Okay. Well, somebody popped up and then now they're not there. I was like, oh my God, they're back. I just ran downstairs right quick. They go get me something to drink. Oh God. Okay, hold on. Jeez, let's go back and play this one until we get back. Oh, they get on my nerves. They ain't like they're coming back and they leave and they come back.
Managing where the money needs to go. When I first learned about Wealthfront,
Photographs, couple of them, as you turn them over, a couple of them have been introduced already into evidence. So just read that number. Otherwise, just put them all face down on the table.
This is the abandoned house on Bradley Street.
What neighborhood is that?
It's in Orange Mountain neighborhood in Orange Mountain.
Did you become aware that there's a house across the street in which Mr. Hernandez Govan lived?
Correct. Directly across the street.
Eventually, does Mr. Govan also become a suspect in this conspiracy to commit murder?
He did.
You can place it down.
That was Exhibit 9. This photo here shows a closer picture of the vehicle in the rear of the yard, parked between brush and trees.
So this vehicle is not parked in the driveway, is it?
No. This is a close-up picture of the Mercedes showing the passenger side with the damage, which appeared that the vehicle may have been sideswiped or something. It's a two-door white Mercedes.
The damage that you can see in the homicide video?
Yes. That's consistent with it. That's Exhibit 10. This photo shows the rear of the Mercedes-Benz, which has an Illinois tag. I need to read the tag and everything.
You place it down.
This is a photo of the driver's side of the white Mercedes-Benz. And this is a photo of taken from outside of the Mercedes-Benz on the passenger side that shows the inside of the rear seats with a Mississippi DeSoto County tag on the rear seat.
It has like another license plate on the inside of it.
Yes.
Maybe even a couple, we'll see.
Yes.
You think this beef is on sale? Not anymore. Aldi doesn't play pricing games on USDA choice beef. They have low prices every day.
Everything we don't do is for you. It's an Aldi thing.
Sorry, guys. I had to go get me something to drink right quick. Stop. Oh.
We, the jury, find the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. We, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. And we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment.
Thank you. Juror number 1, is that your verdict? Juror number 34, is that your verdict? Yes. Juror number 35, is that your verdict?
Yes.
Juror number 11, is that your verdict?
Yes.
Juror number 14, is that your verdict?
Yes, ma'am.
Juror number 17, is that your verdict?
Yes, ma'am.
Juror number 27, is that your verdict?
It is, Your Honor.
Juror number 33, is that your verdict?
Yes.
Juror number 25, is that your verdict?
Yes.
Juror number 44, is that your verdict?
Yes.
Juror number 23, is that your verdict?
Yes, ma'am.
Juror number 28, is that your verdict?
Yes, ma'am.
Thank you. Ladies and gentlemen, I want to thank you again for your time and attention to this matter this week. Our system of self-government would not work without your service and sacrifice that you've made. Thanks again for your time and attention. You are excused.
Jurors excused.
Mr. Johnson, the jury having found you guilty of conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. As the 13th juror, I affirm this verdict. As to the first-degree murder, I sentence you to life in prison.
I said
I
it.
will set punishment as to the conspiracy, then the convicted felon in possession of a firearm after a sentencing hearing. The date for that hearing will be November 1st?
Yes, Your Honor.
November 1st.
Fall in love with Illinois.
Oh,
It's the middle of everything.
When we got the farmer's dog, we did the first feeding and he got so excited.
9 a.m.
Did everybody see? Please put a one if y'all can see, because I know some of y'all see you can't see. He has no emotion. He gonna cry when he get back in the cell. He don't want to cry on camera. That's what it is. Oh, thank you, Jesus. Oh, Lord. So the lawyer got up there with all that talking and still. Right. Okay. All right, let me go back. So this is what I'm gonna do for everybody that did not get to see it. Let's back it back. I want y'all to get to see it, that part again, okay? Let's see. Let's take it back because some of y'all said you didn't see it. Let's see. Okay. All right, let's play it right here.
To the members of the public, if you don't think you're going to be able.
All right, to the one, if everybody can see it, we're gonna look at the verdict one more time for those of you who did not see it.
To remove yourself now.
Please put a one if you can hear and see.
The court won't tolerate any outbursts of any sort from anyone.
Okay, great.
Ready,
The
Your Honor?
nervous rock.
Yes.
The jury's now heading to the courtroom.
Ladies and gentlemen of the jury, have you reached a verdict?
We have your
Four person. If you would stand and read your verdict, please.
We, the jury, find the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. We, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. And we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment.
Thank you. Juror number 1, is that your verdict? Juror number 34, is that your verdict? Yes. Juror number 35, is that your verdict?
Yes.
Juror number 11, is that your verdict? Yes. Juror number 14, is that your verdict?
Yes, ma'am.
Juror number 17, is that your verdict?
Yes, ma'am.
Juror number 27, is that your verdict?
It is, Your Honor.
Juror number 33, is that your verdict?
Yes.
Juror number 25, is that your verdict?
Yes.
Juror number 44, is that your verdict?
Yes.
Juror number 23, is that your verdict?
Yes, ma'am.
Juror number 28, is that your verdict?
Yes, ma'am.
Thank you. Ladies and gentlemen, I want to thank you again for your time and attention to this matter this week. Our system of self-government would not work without your service and sacrifice that you've made. Thanks again for your time and attention. You are excused.
Jurors excused.
Life. I told y'all he gonna get life. I knew it. You a convicted felon and you still out here doing that? That's life, buddy. Wow. He's young. That's so sad.
Mr. Johnson, the jury having found you guilty of conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. As the 13th juror, I affirm this verdict. As to the first-degree murder, I sentence you to life in prison. I will set punishment as to the conspiracy and the convicted felon in possession of a firearm after a sentencing hearing. The date for that hearing will be
You want to cry so bad.
November 1st?
Yes, Your Honor.
November 1st. There's nothing else to take up?
We will prepare the judgment sheet and pass that forward, Judge.
Thank you. And the pre-sentence report. The order for the pre-sentence report.
Sir, let's get that. We'll get this to you.
Thank you. You may adjourn court.
All rise. This honorable court stands adjourned to Monday morning at 9 a.m.
Wow. Okay, so they had like something going on after that. Let's go forward just a little bit because there's like a little news person speaking. Let's get to that. Let's see. Is it gonna play it or did they all? Okay, let's see. Can't hear you, buddy.
Yeah, less than 4 hours. Let me tell you, because they had some time to eat some lunch.
Why is he so
And
low?
then over lunch, they began deliberating.
Can
Over
y'all
lunch,
hear?
the judge gave him that opportunity to do that. And you hear just less than 5 minutes ago, the guilty verdict, finding Justin Straight Drop Johnson guilty on all
I'm all the way
counts,
turned up.
conspiracy to first degree murder, as well as convicted felon in possession of a gun. Now, this, again, coming less than 4 hours.
He's just explaining what the judge said. We can't hear him anyway. Let's stop sharing. So what do y'all think about the verdict, you guys? He is very low. It's so weird. The courts are like boom, and then when we hear him, it's like. But what do y'all think about the verdict? I already knew he was getting life. I knew with everything that he was charged with, and plus he's a convicted felon. I already knew it. But yeah, life. So Justin Johnson, who unalived young Dolph, has received life. Okay. And he has to go back to court November the 1st for his sentencing for the convicted felon, having a weapon under convicted felon, and for conspiracy to commit unaliving. Okay. So yeah, he'll be back November 1st, and we'll see what goes with that. Okay. But we're going to log off now because I'm going to be coming back here soon for our other show. We've been on live, what about 2.5, 3 hours? Jesus, waiting on this damn verdict. But rest in peace to young Dolph, and justice for young Dolph. He got some justice today. All right. Yes, and yes. So let's get on out of here, guys. And I will see you guys in a little bit as I get the rest of my show ready. Okay. Let's get y'all out of here. Love you guys down. Bye.